resume the questions without notice to the Chief Minister. And the next question is from Deputy Gardner.
Chief Minister, in his proposition for 3.6 million acquisition of the seaside cafe at the Crève de l'Ec, stated that its investment aims to utilize the land, environment, cultural and social benefit of the public, preserve historic and cultural significance of the bay, and support ongoing public access to sea swimming and beach use in the west of the island. Will the Chief Minister set out his vision for similar sea swimming opportunities for residents of St Helier, and compare and contrast these two sites, and if he would give the same attention to the Victoria Marine Lake?
Chief Minister.
Thank you, sir. We know that the acquisition, following the acquisition of Crève de l'Ec, the land was passed over to the National Trust, who have got great plans for that, and I support any such similar projects around the island. The Marine Lake is an interesting one at West Park. I remember when it was refurbished some 25 years ago, if I get it right. I remember former Senator Pierre Horsfall, I think, led on that. And in an ideal world, I'd like to see a refurbishment there, but I'm not sure of the practicalities of it now. I'm not sure of the demand for usage there, so I'd like to support it, but I'm not fully aware of what is planned. I think it's slightly different to the Crève de l'Ec situation. Whilst the principle is the same, if Deputy members remember, there was plans for a large residence on the site at Crève de l'Ec and potential loss of use of the car parking and much of the facility. I think slightly different situation at West Park, and I'm still slightly concerned about the green. I'm looking at the Infrastructure Minister to make sure the green weed that's starting to appear in that area again, and that's perhaps slightly more pressing. But look, I would like to be supportive of such a project. I've heard the Infrastructure Minister's views, and I'll wait to see what happens. I'm sorry I can't be more helpful than that.
Supplementary.
Absolutely. As a remark of the green, it's 3 months and 9 months as residents of St Helier can use. Would the Chief Minister expand why the cultural environment and well-being benefits of the Crève de l'Ec are higher than the Victorian Marine Lake swimming? It's only sea swimming for St Helier residents that actually we have for the west part of St Helier.
I'm not sure I see any preference for islanders wherever they go, but the Crève de l'Ec situation is I see it as completely different situation to the refurbishment of the Marine Lake at West Park. We're talking about refurbishing a certain piece of infrastructure there, not access to the shoreline. So I think it's I don't think you can compare like for like, although the principle of providing safe, useful shorelines is the same. But this is about a piece of infrastructure that needs to be repaired. And whilst in an ideal world, I'd like to see a flourishing Marine Lake there, whenever we've tried that in the past, there hasn't been the public engagement, and it's never been used. But perhaps not in credit to the Assembly and for we've never really maintained it or kept the maintenance up. Like I say, I think I would prefer to see a really good solution to the Lido. I mean, we can look to Guernsey to what they've done there, and I think perhaps investment in the first instance might be better directed at the bathing pool in that area. But it's a matter yet to be concluded, sir.
Deputy Chair.
Thank you, sir. Could the Chief Minister outline his position on how Jersey should respond if an international partner, whether a government or financial institution, undermines the international rules-based system or breaches international law?
Chief Minister.
Sorry, sir, could you just repeat the last sentence?
Yes, could you repeat the last part of your question, Deputy Chair?
How should Jersey respond if an international partner, whether a government or financial institution, undermines the international rules-based system or breaches international law?
Yes, Chief Minister.
I think it's difficult to answer that question, sir, without more context. If we're talking about international partners, are we talking about financial service companies? Are we talking about countries in breach of law? Are we talking about perhaps the deputy could just provide a little more context, sir?
Yes, of course. I was just wanting to understand what the Chief Minister lies when partners, mainly governments like Jersey works with, if if those partners undermine and breaches international law, how will Jersey respond? Does the Chief Minister have a position on this?
Well, our key partner, of course, is the United Kingdom government, who we work very closely with. They are responsible for foreign affairs and our defence, and we are usually aligned with them. For example, sanctions tend to be automatic, and we follow suit where the United Kingdom government does that. It's not been our policy, and I don't propose it is at this stage, without further discussions with the External Relations and Council of Ministers to break from that which we followed for many years. Thank you, sir.
Supplementary?
Yes, sir, and the Minister asked for an example. So does the Chief Minister believe the UK's current approach to the conflict in Gaza, including its arms exports to Israel and diplomatic positioning, aligns with this international rules-based order or breaches international law?
Well, I'm not sure. I'm not qualified to say whether it breaches international law. I've said before I'm absolutely appalled at the humanitarian situation that's unfolding in Gaza. I'm very uncomfortable with the response to that from most Western governments. So I would, and we voice our opinion, we share our opinion with Westminster through external relations. So I remember back, I think it was in 2004 when the States passed a proposition in relation to the Iraq war. We haven't reached that stage yet with what's happening in Gaza, sir, but we are continuing to follow the UK's position there, sir. But I would reiterate personally, as Chief Minister of Jersey, I'm uncomfortable with the way the West has responded. I'm appalled at the situation in Gaza, and I would do anything, do anything this small island can do to assist. Thank you.
Thank you, Chief Minister. That brings your 15 minutes to an end. The time, of course, began before the adjournment. There are no matters under J or K. That brings us on to public business. The first item is the draft Electoral Registers Jersey Amendment Law, lodged by the Chair of the Privileges and Procedures Committee. The draft law was previously referred back to the committee, and in the circumstances, the debate in effect begins again, and I ask the greffier to read the citation.
Draft Elections Electoral Registers Jersey Amendment Law 2000, a law to amend the Elections Jersey Law 2002 in relation to electoral registers and for connected purposes. The States, subject to the sanction of His Most Excellent Majesty in Council, have adopted the following law.
Chair of PPC.
Thank you, sir. The changes proposed today by PPC will create an automatic voter registration system, replacing the current paper-based process with a database created from the People Directory. Instead of the public having to complete an annual statement to confirm the names of those who are eligible to be on the electoral register, people will be included automatically on the register if they are over 16 and meet the relevant residency criteria. The database comes from interactions with Revenue Jersey in relation to social security matters, the register of names and addresses, and information held by SIPES for those still in full-time education aged over 16. PPC believes that this system will be more accurate than the existing system, which accepts people's statements on trust and is not verified by the parishes. This system will also better reflect the position closer to the election date, rather than using data gathered over 6 months earlier. The proposed system will allow for a more recent sweep of the data taking account of changes such as people leaving the island or passing away. The reasons for making these changes are to make it easier for people to vote automatically, including anyone who is entitled on the base electoral register, increase the democracy of our electoral process by removing barriers to voting. The main changes within the legislation are the removal of the individual's duty to make a declaration of entitlement, removal of general public access to the register. Under the current system, people can go to their parish halls to check the electoral register or inspect copies in the library or at the judicial greffe. As the electorate will not be able to opt out of the system, PPC feels it is only right that the general public's access to the register is removed. This will ensure that people cannot access the register for improper means. At present, it is really a stalker's charter. In the new system, the register will only be available to electoral administrators and the judicial greffe, with a copy provided to the archive on an annual basis as a historic record. Following feedback when this matter was debated in May and concerns expressed about candidate safety, PPC have brought forward an amendment to the draft legislation which allows for anyone who has been formally declared a candidate in an election to apply to their electoral administrator for a special list of names and addresses of those living in their constituency. The candidates list will allow them to select which houses they wish to visit and which to avoid, especially if the residents are people they know to be unsupportive or particularly confrontational. PPC recognises that there is an inherent risk associated with door knocking, and whilst this amendment will provide some comfort to candidates, as an additional measure, we will be asking the Jersey Electoral Authority to provide detailed safeguarding guidance for all those heading out on the campaign trail. The existing system allows islanders to apply for their name to be omitted from the register if they are concerned that there is a risk or threat of personal harm to themselves or someone who resides with them, if their name and address details were to be made public. The new system will offer the public the ability to opt out of inclusion in the candidates list, but they will remain on the register and be able to vote. PPC feels this amendment provides a practical workaround which does not make standing for election harder or less safe for candidates, whilst equally providing protection for the public and their personal data. The new register will include people who may have previously made a conscious decision not to make a return, either because they had no interest in voting or did not wish to be included on the list for jury duty. It is estimated that only 60% of statement forms are returned to parishes. By increasing the accuracy of the register, we expect that there will be an increase in the total number of people included, and this change will therefore also benefit the judicial system. And there has been a significant rise in the last couple of years in cases of requiring juries. The scope of the AVR project was recently extended to include the tirage jury selection process, as it was identified that the new database would not work with the existing tirage system, which is nearing an end of its usable life and is no longer supported by digital services. We are assured that it is not complex to ensure the systems work together, and it will allow for the relevant data to be extracted to provide a list for jury selection. Islanders will be able to check online to confirm that they are on the register using a special self-verification app which is under development. If they are not registered, they can approach their parish and be added, if they can prove that they have lived in Jersey long enough. The electoral administrator, the parish secretaries, will still have power to add or remove a person from the register. We don't expect that many people will need to be added in this way, and Vote JE will run campaigns explaining the new system to everyone from the new year. The system will also be able to identify future voters, those who will be turning 16 on election day, or who will have met the residency criteria on the date. Again, communication is key, and Vote JE will target messaging to those who have moved to the island in the last 2 years, reminding them of the need to check they are included, where appropriate, on the register. A supplementary register will be available up to 7 working days before the election, and this will accommodate anyone who moves home in that period. A person who appears at the polling station on the day of the election but is not on the register will be able to be added to the register by the electoral administrator if they have their supporting documentation. The electoral administrators in each parish will retain overall responsibility for the register. Although there is a risk that a more inclusive electoral register will see fewer people voting percentage-wise, PPC is hopeful that the opposite will happen. We believe that those who might have been unsure they were eligible to take part will be encouraged that we value their voice and they will be inspired to participate and vote. Through Vote JE, the GREF will run a dedicated communications campaign explaining the changes, highlighting that people may now be eligible who may not have thought they could participate, and everyone will be encouraged to exercise their democratic right and use their vote. I urge members to support the principles. Thank you, sir.
Thank you, Chair. Are the principles seconded? Does any member speak on the principles? Deputy Miles.
Thank you, sir. Whilst I understand the reasons for the introduction of this measure and the benefits to government, I'm still concerned about the automatic inclusion of people's names onto the electoral register. And I'll repeat what I said at the last sitting. If a person doesn't want to be included in the electoral register, they have no means to get off it. And this is what concerns me. It clearly states in the report the electorate will not be able to opt out of the system, and the chair of PPC has just confirmed that. I've been to the briefings and this still hasn't been satisfactorily addressed to me. So in this case, automatic means compulsory, and I would prefer to see a mechanism whereby a citizen can remove his or her name from the electoral register. I can see how it might be removed from any version that is provided to candidates, but there doesn't seem to be a mechanism to be removed completely, if that is your wish. I've read the human rights notes accompanying the law, and they state that Article 8 ECHR rights are not impacted, partly because the register is not open to inspection by the public or by candidates. It actually says the draft law would, amongst other things, allow the transmission of personal data from a variety of state sources to the Chief Minister and to the Electoral Administrator. The data would not be publicly available, as the electoral registers would not be open to inspection by members of the public or by candidates. To that extent, if any, that this arrangement could amount to an interference with a person's Article 8 rights, it could be justified as a proportionate measure in pursuit of the legitimate aim of increasing voter registration with a view to increasing voter turnout and general engagement. That is no longer the case, because candidates will be able to see the electoral register and possibly their supporters, unless a person gives written notice that they want to be removed from the special register. But this just gets them off the special register, not off the actual base register. I totally understand that Article 3 of ECHR recognises the importance of fair and accessible elections as part of rights related to political participation. But while full automation might reduce barriers, individuals should generally have clarity and control over what they're being signed up to. In the UK, I understand that an individual has to register to vote themselves. There is a permanent electoral registration system which uses existing government data to facilitate voter registration, but this is still voluntary. And whilst the PER system streamlines the process, eligible voters still need to ensure that their details are correct. The government encourages participation using this system, but it doesn't mandate it. I can't think of any other register where you can be registered by the state without your express consent and the opportunity to opt out of registration. Are we adding people to a register without informed consent and thereby invading their privacy? In this case, any person who is considered to be registerable will be added, whether they consent or not. As I've mentioned, Article 8 protects the right to respect for private and family life, home and correspondence. The key points: it safeguards personal privacy and family life. Any interference by the state must be lawful, necessary and proportionate. If this law is passed today without an opt-out, of course it will be lawful, but I'm not sure it's necessary or proportionate. There hasn't been any public consultation on this, and I'm very concerned about the issue of informed consent. And the other issue that I wanted to raise again, that I don't think has been addressed thus far, other than for the chair of PPC to clarify that people on jury service will be selected using the automatic voter registration system, is that people we know already have said they do not wish to be registered because they do not wish to take part in jury service. I know all the arguments about being a member of the jury as a civic duty, as is the requirement to vote. But as I've said before, the 2018 law has very limited number of exemptions. So I'd like perhaps if the chair of PPC to address this issue. I'd really like to know whether an updated human rights assessment was taken when the amendment was proposed to include the permission for candidates to view. And I just would like to say, I know I am in the minority here, but I wanted to ensure that my concerns are recorded for posterity. Thank you, sir.
Thank you, Deputy. Deputy Scott.
Sir, I'm going to echo my fellow Brella Deputy Helen Miles in a respect, though with a slightly different emphasis. And mine is in the case of the treatment of personal data. We, as an assembly, as in a government, invest a lot in terms of data protection. And I have had some concerns about the nature of the advice that might well be given in some areas in this respect, and the extent to which any dialogue has taken place with people like the Data Commissioner, just to have a little bit more clarity about whether what we're doing is really, again, compatible with modern standards of personal data treatment. So I will likewise be grateful if the chair of the PPC will advise the Assembly on any advice taken on that and received. Thank you.
Thank you, Deputy. Deputy Tadier.
So first of all, I'd like to start by thanking the chair of PPC and her committee for taking this away and working on it and improving it. I think that's what's happened. I know that sometimes it's not easy to come into a debate and then get faced with the barrage of criticism when actually the vast majority of what you've been presenting and working on is absolutely correct and it's in the right direction. And I think what we've got back is a bigger improvement, and I'm certainly happy with it. I'd like to respond to, I think, the two comments that have been made, the two interventions from previous speakers. And I think what this boils down to is that you either believe in automatic voter registration or you don't. You can't have it both ways. There will be inherent tension between those liberties on the one hand that members are perhaps trying to fight for and actually having a system whereby everyone's registered. If you're automatically on a register, you're on the register, and I think the safeguard that's been put in place is that if you don't want certain people to see it, i.e. the candidates, you get your name removed and put on a back register, which means you can still vote. When you turn up to vote at the parish hall, at the community centre, the people who need to know will know that you're registered, and the people who don't need to know, in this case it's the candidates, they won't know, but and similarly that you won't have to get a knock on the door necessarily from them. What it does mean, though, is that when any candidate is out electioneering, putting their manifesto forward, putting their ideas forward, when we or they get anyone coming to them saying, actually, I'm not registered to vote, we already know that happens, and you say to them, no, actually, you are registered to vote, and they say, oh, I didn't register, and they say, you are, so don't worry about it. In fact, that kind of possibility will no longer be the case. Everyone will know that they're registered to vote. Candidates will no longer have to go around and perhaps consider whether they need to do a voter registration campaign before election comes up. The parish hall won't have to do that because everyone will automatically be registered to vote. There are other registers, it's just we won't necessarily call them registers. Government does hold lists of people who live in the island for different purposes. It's just a question of legitimate access to those lists for legitimate use. That's what we're talking about. And I think the questions that have been raised are probably best put to the Solicitor General in this case. If any member does have questions about whether the human rights statement that's been issued alongside this proposition here is valid or not, then that can presumably also be asked by the Solicitor General. But for my part, I'm quite comfortable with that. As somebody who does take an interest in human rights and in personal privacy, I think that this proposition strikes the right balance. It does mean, of course, that there might be a shock in the initial elections when we have 100% of people, at least in theory, registered to vote. Not everyone's going to use that right to vote, and so we may see statistics going down, but it does mean that at least more and more people will have the opportunity to come out and vote, and I think this is a positive. So bearing in mind that this is very much the in principle that we're passing initially here before we go on to the second and third readings, I for one am very happy to support this proposition. I think it's a much improved one, as I said at the beginning, much improved one. And if there are particular technicalities to discuss, let's do that when we come to the different articles.
Thank you, Deputy. Deputy Oz, if your light was on briefly.
So I wonder whether or not the Solicitor General the President may be assisted, the Chairman may be assisted by the Solicitor General's observations on Article 8 of the Human Rights Law. I, like Deputy Tadyer, don't want to repeat what he said, but I think the Chair of PPC, if I may say, has a very difficult job to do. She's listened, and her committee's listened, and they've brought forward what is a reasonable adjustment. And I don't understand quite why, if an individual is completely hidden from view, then why there is a problem. The candidates can't see it. Maybe the President kindly, in her summing up, may say whether or not you can opt out from receiving information from the excellent work that the Grefia does with vote.je. Maybe candidate, we can just be informed if they will get that information from vote.je, but that will still be private. It'll be addressed to the individual, even if that does exist. And I just wonder whether or not Deputy Tadyer is not right in saying that this is a proportionate and proper use, and the PPC has made necessary arrangements. The complete prohibition was undoubtedly uncomfortable for some members. We do have dreadful voter turnouts, and that's what I think the committee is trying to do, and the President's trying to actually improve our voter turnout. But nevertheless, the privacy issues are hidden from view. Is this just about basically being selected for a jury? Is that what the issue is? But I support entirely what PPC is doing. It seems proportionate, and I'm sure the Solicitor General can give us comfort.
Do you have a question for the SG?
Well, is it in contravention? I mean, the question's been asked and casting doubt on what the committee said in terms of a human rights statement. And if the Solicitor General may just say what's already written, I've read it. It says it's compatible, that you should be given advice that it's compatible, and maybe he could address the Assembly and say that he's satisfied, because then it must be.
Yes, question for the Solicitor General.
I'm satisfied that it doesn't amount to a breach of Article 8 of the Convention. The tenor of the advice that was given, and which appears in, I think, page 5 of the report to the original proposition, was very much predicated on the primary basis that the electoral register as proposed does not amount to an infringement of the right to respect for private and family life, home and correspondence. Then it goes on to say, somewhat in the alternative, but even if it could be suggested that it did, proportionality or disproportionality is not engaged. Well, I hold very much to the primary thrust of that advice, which is that there is no breach to begin with of the right to respect for private and family life. Why? Because the electoral register will be private insofar as it is disseminated in its detail to a limited class of persons, that is to say election candidates. Individuals have the right under law to opt out of that process. So that's my view, and it's fairly firmly my view. And of course one bears in mind that it might be said that having an electoral register that works in the way that is proposed actually serves to promote the Article 1, Protocol 3 right of promoting free and fair elections. The high contracting parties undertake to hold free elections at reasonably intervals by secret ballot under conditions which will ensure the free expression of the opinion of the people in the choice of their legislature. And it might be said that the easier it is, as it were, to be able to vote because you're on the register, the more the free expression of the opinion of the people of the choice of their legislature is promoted. So that's my view.
Thank you.
So may I ask a
Yes,
question? It's a separate question, but it has arisen from something that's already been said by other speakers. Could the Solicitor General confirm whether or not jury service is obligatory for everybody who is on the electoral roll if they get called. So anyone who's on the electoral roll has the potential to be called for electoral service if they're not disbarred for a different reason.
Lister.
Well, I think subject to any disbarment, anyone who's on the register is liable to be called for jury service. Whether they in fact undertake jury service ultimately will be a matter for the court when they attend for any trial.
Can I just thank the Solicitor General for his answers, comprehensive answers? I'm certainly satisfied, and thank the President.
Deputy Scott, other question?
So just, yes, to add, just to direct as has been suggested, my question regarding data protection, law compliance of these arrangements.
Well, the arrangements, if they are adopted, will be compliant with the data protection law. What I understand is proposed, and this accords entirely with advice, public advice, which the Information Commissioner already gives to candidates for election, is that they will become data handlers, controllers, forgive me, of any electoral register with names and addresses on it, and they must register as candidates with the Information Commissioner, and they are then bound in the way they use that information by the terms of the data protection law and the data protection principles. So, first of all, it is not inconsistent with the data protection law, and the way it's proposed to operate will bring all those who have access to that data within the purview of that law and an obligation to abide by it.
Other question?
Yes, just so are all aspects of consent therefore covered, please?
Yes, there's a very helpful data protection guidance for candidates for election, which is I say publicly available from the Information Commissioner, which sets it out in the sort of terms that even I can understand. I think the practical advice I'd give is practical, which is that if candidates are in any doubt next year about what their obligations under the data protection law are, the ideal thing to do would be to seek guidance from the Information Commissioner's office. I'm sure they'd be willing to give it.
Sorry, sir, I wasn't clear. I meant about the consent to get on the register.
Oh. Yes, I don't see that raises data protection issues at all. It is how that data is then used by the data controller and any data processor, which will raise data protection issues. But the mere fact of saying by law, you will be on the register and that's that, does not engage the data protection law, and it does not contravene it.
Thank you. Deputy Renouf.
Thank you, sir. I think quite a few points have actually been covered by the Solicitor General, his interventions. I'm very grateful. This is a rare example where I disagree with my fellow St. Ballard Deputy Miles, because I do think that this is a very welcome modernisation. It does seem to me archaic that in this day and age that we have to, might still have to register voters and to do voter registration drives and so on. So the ability to have a much more responsive and up-to-date register, which can respond right up to the point of election day, feels very, very useful. And my own take regarding there being no means to opt out from the register is quite apart from the legal issue that it doesn't matter, because the substantive underlying concern doesn't actually cause a real harm. I think it's part of the social contract, really, that you join a society, you would expect to be a part of the electoral register. The public won't get to see the register. Candidates will also not be able to see the electoral register, but they will be able to see, this is assuming we pass an amendment, of course, we'll be able to see the candidates list, which people will be able to opt out from. So privacy is safeguarded in that regard. And it is the exposure to candidates that is to do with personal privacy, and that privacy is safeguarded by the amendment, or will be safeguarded by the amendment. So I think it is proportionate and necessary, and I also agree with the idea that the idea that jury service should be compulsory, and you shouldn't be able to opt out just because you fancy not doing jury service. Again, feels to me to be something where there's a social contract and a reasonable expectation on citizens that they should partake in those things. And so I support the principles of this, in particular in the light of the amendments that have been brought.
Thank you, Deputy. Does any other... Yes, Conatable of St Brelard, then St Saviour, then Deputy Howe.
Thank you,
St
sir.
Brelard.
First of all, I must, well, is it apologise to members or remark to members that the Comité de Conatable have submitted lots of amendments, comments and amendments to amendments with a view to getting this right. I think we've all understood, sir, that last-minute changes are never good, but I'm grateful for the input from the GREF and the Comité Secretary, who have got much experience in these things and have picked up all sorts of glitches along the way, which we've tried to resolve in our amendments. I think in reference to Deputy Miles, sir, the draft, well, we have the amendment 2 and amendment, which basically says the second amendment to P27 presented by PPC provides the candidates standing for election should have access to the electoral registers for the constituency in which they are standing. As the names and addresses held by government will be used to compile the electoral registers, PPC have also provided an opt-out arrangement. This means that an elector who doesn't wish their name and address to be supplied will not be on a copy of the electoral register provided to candidates. The automatic voter registration project is expected to add more persons to the registers. These are persons who currently choose not to register to vote. The reasons may be various, but could include those who have no intention of ever voting or do not wish their names or addresses to be in the public register. And this may include those who work in the police or prison service, amongst others. And also some who choose not to register as they believe they'll avoid jury service, as has been mentioned. That also affects children and young people, such as those aged 16 years and under, or over, who are eligible as electors. We have a task force to reduce violence against women and girls, and issues of domestic violence are also a concern in Jersey. Any of those persons may also choose not to have their names and addresses disclosed to candidates. So as explained in the Comité's report with the Amendment 2 to the Second Amendment, with regard to the Data Protection 2018 law, sir, it would suggest an opt-out or an opt-in to the candidates list rather than the opt-out might be preferable, and I'd like to think that answers Deputy Miles's point. Electors who opt out from the candidates list are likely to expect this to remain in place until they change their decision, rather than automatically that it be revoked on moving from one parish to another, and we've tried to overcome that one too. The Comité's amendment simply provides for the opt-out to remain with the elector until the person revokes the opt-out. The financial and staffing implications will depend on the state's decision as to the process and the solution developed in support of the process. So I do believe, in reference again to the opt-out process, if members wish to look on Amendment 2 at 12C, that does clarify a lot of the points made. Thank you, sir.
Conatable of St Saviour.
Thank you, sir. In P28, sir, there's several references to deputies and constables. As we have a large number of people positioning themselves now for the elections, could the chair of PPC state that she is completely satisfied that all the legislation will be in place for the reintroduction of senators in 2026? Or are we having another 4 years of deputies and constables only? Thank you, sir.
Thank you. Deputy Howe.
Thank you, sir. And I'd like to thank the PPC very much for all their hard work and then having to go through the legislation again when it was called back in. My concerns are that I think we may get a reduced voter turnout at the next election if everybody is placed on the... It could go the other way, but I just want to highlight that. And I do think I would like to have an opt-out so that if you can be put on to the register up to the last minute of the election, I think also you should be able to ask if your name could be taken off. But those are my comments. Thank you, sir.
Thank you. Deputy Mezek. Deputy Miles, do you have a point of clarification?
I had a point of clarification for the Connétable St Brelard, sir, but I think if he's prepared to...
I think you may have missed the boat because he's
Okay.
finished speaking. That may be my fault for not missing your light. I do apologise for this. Yes, Deputy Mezek.
Thank you, sir. I was provoked to put my light on because the comments from Deputy Howell about this leading to a lower voter turnout. To explain why that's not the case, it may well lead to what will, from some angles, look like a lower turnout, but in reality it won't be a lower turnout. And so that arises from the fact that until now, when voter turnout statistics have been officially reported in Jersey, they have been done on the basis of registered voters and not eligible voters. So I have resisted that at every opportunity I've had. I don't consider that to be a legitimate figure because it ignores the swathe of our population who are eligible to vote in elections, but for whatever reason didn't register to do so, and therefore actual voter turnout is determined by turnout of eligible voters, not registered voters. What this proposition will do is that it will stop there being a difference between those two figures, because eligible voters will automatically be registered voters. So it will not lead to fewer people voting. In fact, it can only really lead to more people voting, because people who mistakenly believed that they were registered but turned out and they weren't, won't encounter that problem at the polling stations in future. So what this will do is it will mean we end up with more reliable and robust data on electoral participation, and that can only be a good thing, and I thoroughly commend the Chair of PPC for bringing this forward, and it has my full support.
Thank you, Deputy. Does any other member speak on the principles? I call upon the Chair to reply. Chair.
Thank you, sir. And I thank everyone who's taken the opportunity to speak. To Deputy Miles, I'm grateful to the Solicitor General that he's answered a lot of members' queries. And really, human rights and informed consent, people still have the right to choose whether to vote or not. Unfortunately, you can't have an automatic voter registration if you allow some people to opt out, because then it's not automatic. And we don't have it, it's not automatic for people to choose whether they want to pay their taxes or want to pay their rates. So I don't have a problem with the automatic voter registration. For those, I do have some sympathy for those who really have avoided voting because they don't want to be in a jury service, but I do believe, and I think the former Viscount told us in the briefing, that there are quite often reasons that people can opt out of jury service if they are chosen. So I do have sympathy with that, but to not try and modernise our we're doing everything we can to try and engage the public, and to just do that for a few who don't want to do jury service didn't seem to be a very sensible thing to do. And really, we want it to be civically engaged, and the intention is for it to be far more inclusive. And I'd like to assure everyone that the amendment was reviewed by the law officers and considered to be compliant. And Deputy Scott, the Data Commission is due to review the practical application of the law and the system before it goes live as part of the project process. And I thank Deputy Tadia as well, who's fully supportive of this, and Deputy Mezek, and to the Constable of St Saviour. This law had to be drafted as per the current system because the senatorial reinstatement, it is due to be lodged. It's going to be lodged imminently, and I'm making sure of that, and it's due for debate in early autumn. But we couldn't include senators on this legislation because they haven't been legislated for. So it's not because we didn't, we've just decided we didn't want to put them on there. It's due to legislation. So, and I'd just like to say that I think that's, I did have some notes for summing up. So it's just really to reiterate that although online voting remains a desire for many, having a digital register represents a step towards modernising the election process, as well as increasing the accuracy of the register and making the process simpler for the public and parishes. Automatic voter registration has shown promise in addressing turnout among historically underrepresented groups by making the process more accessible. Increased registration rates among minority groups have been observed in those places which have automatic voter registration, such as the Netherlands, Sweden, Germany and Canada, which suggests that adopting this registration system can play a significant role in promoting greater political equality. All those countries also enjoy consistently high voter turnout, and PPC hopes that this will also be the case in Jersey in 2026. I make the principles and I ask for the appel. Thank you, sir.
Thank you, Chair. The appel has been called for. Members are invited to return to their seats. I ask the greffier to open voting. If all members have had the opportunity of casting their votes, I ask the greffier to close the voting. I can announce that the principles have been adopted. 43 votes pour, 1 vote contre.
Deputy Miles.
Deputy Miles, do you wish to scrutinise this matter, your panel?
Absolutely not, sir.
Has it been scrutinised, sir?
Not by, no. We now come to second reading. There are some amendments, one by PPC, to which the Chair has referred, two by the Comité de Connétable. Chair of PPC, you're prepared to accept the amendments from the Comité?
Yes, so we would like to propose the articles as amended by our own amendment, PPC's amendment, and the committee's two amendments, which we accept. Thank you, sir.
Members content to take the legislation as amended? Yes. How do you wish to propose the articles, Chair? There are 26.
I'd like to propose the articles en bloc, please, sir, and I'm happy for the votes to be taken on separate articles if members so wish. Most of the articles are administrative in nature and will underpin the proposed new system. There are a couple of significant changes which I should draw attention to. Article 11 deletes the current provision for electoral registers to be available to view by the general public, whilst the amendment to Article 12 allows for a special candidates list to be provided only to those who have been formally declared as candidates. PPC considers that there is sufficient justification to close the register to the general public, but believes that this amendment provides a practical workaround which does not make standing for election harder or less safe for candidates, whilst equally providing protection for the public and their personal data. This amendment proposes that candidates be provided with a list of those on the electoral register once they have been formally declared a candidate at the end of the nomination process. At that point, they will be required to register with the Jersey Office of the Information Commissioner under the Data Protection Jersey Law 2018 and to complete a declaration prior to receiving the register. It is anticipated that this will serve as a sufficient deterrent for anyone who might access or use the register improperly. PPC accepts that the process of door knocking during election time is a Jersey tradition, but there is a risk in canvassing on anyone's doorstep, whether you know their name or not. Although the amendment proposed will provide candidates with a list taken from data used to compile the electoral register, islanders will be able to opt out of appearing on that list if they write to the electoral administrator of their parish. As an additional measure, the committee will be asking the Jersey Electoral Authority to provide clear guidance to all candidates to ensure they are mindful of safeguarding when conducting their campaigning in 2026. Sir, I propose the articles and call for the appel.
We'll come to the appel in due course, perhaps. Are the articles seconded? Are the articles seconded? Thank you. Does any member wish to speak on the articles in second reading? Deputy Scott.
Yes, sir. I am concerned that Article 9A just refers to elections of deputies and connétables in the context of the approval of the by the Assembly of the inclusion of senators, and just wondered whether quite what happened, that there wasn't an alternative it suggested there wasn't an alternative possible about just saying elections for state members. Thank you, sir.
Thank you, Deputy. Does any other member to speak in second reading? Yes, Deputy Ozef and then Deputy Taddy.
I asked whether the legislation has been scrutinised, but obviously the constables may have a calling, so they've scrutinised the legislation themselves. And some people I know don't want the constables here, but if they've done a line-by-line scrutiny of it, then we've been well served by the Comité des Connétables. And I think that actually we've ended up with a better piece of work, sir.
Thank you. Deputy Taddy.
Yeah, it's food for thought, isn't it? Imagine the constables being in a scrutiny chamber somewhere away from here, or even here on a different week. Be careful what you wish for, hey? But I think the serious point to be made here is that scrutiny has been done of this legislation. It's been done in the first instance by the Assembly when the principles came for debate. It's then been done by the Comité des Connétables, who've got clearly an interest and some expertise in this area. And it's been re-scrutinised by PPC with a different pair of eyes, if you like, a fresh head after a debate which they no doubt felt a bit scathed by, but I think ultimately did the right thing and did a good piece of scrutiny. So simply on that area, sir, before we get to the articles, I think there is a question actually in future whether PPC should be scrutinised by a scrutiny panel. I think it's one of those. I don't think it should be, is what I'm saying. I think the question needs to arise. It's not a government department. It's a department. It's a Gestalt entity of the Assembly, and as such, it's already made up of a deliberately diverse group of people, and it's our jobs and whoever is in this position in the future in our seats to scrutinise whatever comes out of PPC, because it's in states members' interest and in the public interest for us and for those future states members to do that, sir. I wanted to speak again in favour of those articles which will give effect to the automatic registration, and it was just occurring to me when the Constable of St Bullard spoke earlier about the ongoing and important Vogue piece of work that is at the centre, quite rightly, of governments and many departments' work at the moment, that when an electoral form currently comes through to a house, there's often, not always, but there's often a gatekeeper for the post in any given household, and depending on what that household is, depending how democratic it is, so to speak, internally, that one person who controls the post may control ultimately who is registered to vote and who ultimately gets to vote. So I think whether it's for spouses, partners who may be in difficult relationships, or indeed children, because we know that children probably don't always get to see all the posts. They simply might get something put in front of them saying, I need your signature here, you're over 16, you're still living at home, to make sure that you're registered to vote. So I think it's really key that we do this for a more inclusive system whereby everyone, whoever they are, whatever power relationship they have domestically, that they will all be empowered equally, at least to be on the register. It doesn't mean that all the problems will be solved, because there can still be coercion that takes place in households. I know certainly I've knocked on doors many a time and the response comes, I'll just go and get my husband, or I'll just go and get my wife because they're the ones who vote, I don't bother voting. And it's a very strange response that you get, but who are we to judge different family dynamics? But I think the strong message is, I think for all candidates knocking on a door, is that you want to feel that you've spoken to everybody that you can to within a particular household, because they're all individuals. They may vote differently, of course, but we can't force people to vote. But what we can do in these articles, and in particular those that make voter registration obligatory, is that we give everybody the same power, same starting point to be registered in the first place. So I welcome again these articles and the amendments, which I think do put in proportionate safeguards, and I do thank the constables also for the work that they've done in improving this legislation.
Thank you, Deputy. Does any other member speak on the articles? I call upon the Chair to reply.
Thank you, sir, and I thank everybody who's spoken, and I wholeheartedly agree with what Deputy Taddy has just said, and I would like to say to Deputy Scott that it's been drafted, the legislation for this has been drafted by the same drafter who's working on the senatorial draft, and this was the best way to deal with the matter. So I hope that answers your... Well, we have to take advice from good law drafters, so... Anyway, I propose the articles and I call for the appel, please, sir.
The appel has been called for. Members are asked to return to their seats, and I invite the greffier to open the voting. All members have had the chance to cast their votes. Then I ask the greffier to close the voting. Announce that the articles have been adopted in second reading. 42 votes for, no votes cast, and 1 abstention. Do you wish to propose the matter in third reading, Chair?
Yes, please, sir. I'd just like to thank everyone who's spoken and supported these proposals and to the committee for their amendment. There's always an element of risk associated with the change, but PPC considers that the risk in bringing forward AVR is one which we can all help to mitigate. The risk is that those people who didn't put themselves on the register in the past for whatever reason will still choose not to take part in the electoral process. If they do not vote, our already low turnout figure will plummet even further. We can all play our part, whether we're standing again or not, by encouraging everyone to vote and making sure that the public are aware of the ways in which they can cast their votes next year, either by post or pre-poll beforehand or in person, at our first ever Sunday elections on the 7th of June. Thank you, sir.
Thank you, Chair. Is the law seconded in third reading? Does any member wish to speak on the articles as adopted in third reading? Deputy Oser.
So I was slightly taken aback by Deputy Tadier's gestalt wording, and I was trying to find a suitable way of finding the way that to thank the constables and the chair of PPC. I can only say that I think the constable is the zeitgeist of her time. That means the time spirit, the spirit of her age, and I think that she and her constables, who do look good there, sir. I'm just a bit worried that they're going to have to move somewhere else. The constables are a blend of parochial tradition and evolving civic expectations, and that should be about voter turnout and getting more people out to vote, and I hope that they're still sitting over there so we can look at them nicely next time round. I'm sure they will be. Thank you, sir.
Thank you, Deputy. Does any other member wish to speak in third reading? Yes, Deputy Scott.
So I also want to commend all the work that's been done by the constables and the PPC on this matter. I have abstained, and in doing so, I just want to say it's not so much about any lack of confidence in the PPC on the matter, but maybe I just have some questions in my mind about the approach of the law draftsman. Thank you.
Thank you, Deputy. Does any other member wish to speak in third reading? I call upon the Chair to reply. Chair.
Thank you, sir. I think I've spoken enough, and I've got more to say for the rest of the afternoon, so I'd just like to propose the articles in third reading, please.
Thank you. The appel is called for. I invite members to return to their seats and the greffier to open the voting. all members have had the chance of casting their votes. I ask the greffier to close the voting. Sorry. And I can announce that the law has been adopted in third reading. 42 votes for, no votes contra, and 1 abstention.
Sir, can I ask a point of order, please?
Yes.
This morning there were a couple of Standing Order 12 requests made, and I wondered whether you had had time to rule on those, and if not, when you were proposing to do so.
I think standing orders require me to respond by 9:30 tomorrow morning, so I promise you I'll do so before 9:30 tomorrow morning, probably this evening. The next item is the Draft Elections Jersey Amendment Law, lodged by the Chair of the Privileges and Procedures Committee. The debate resumes following the adoption of the principles on the 14th of May and referral of the draft law to the Corporate Services Scrutiny Panel. Chair of PPC, there is an amendment lodged. One amendment lodged by Deputy Jeune to Article 4. Is that amendment accepted by your committee or not?
PPC is broadly supportive of Deputy Jeune's amendment, but we would like the Assembly to determine whether the residency criteria should be reduced. So we'd ask that the amendment is debated separately. Thank you, sir.
Yes. How do you wish to propose the articles in second reading, Madam Chair?
I would like to take Articles 1 and 2 first.
Yes, so 1 and 2 first, and then come on to Article 3,
Yes.
which deals with prisoner voting.
Yes, please, sir.
Yes. Do you want to say anything in relation to Articles 1 and 2?
I'll just make a general speech for the principals, and I'd really like to thank the Corporate Service Scrutiny Panel for their comments paper. Most of the proposed changes to the Elections Jersey Law 2002 are administrative in nature and designed to improve the electoral system for candidates, voters and those tasked with running the process. They are based on the recommendations contained within the CPA Election Observers Mission, EOM Report 2022, published after the last elections, and also the report of the Jersey Electoral Authority, R3 2023, and feedback from the electoral administrators. Probably the most contentious element is an amendment to Article 4, which I think is Article 3.
It's Article 3 of this law.
It's Article 3,
yeah. It's amending.
Of the elections, or in response to one of the election observers mission's recommendations, and would extend voting rights to all prisoners based in Jersey. Currently, those detained in Jersey for longer than 4 years are disqualified from voting. In 2005, the European Court of Human Rights ruled that the UK was in breach of Article 3 of Protocol Number 1 of the European Convention on Human Rights in relation to prisoner voting rights. The central element to the ruling was that the UK's then blanket ban on prisoner voting was indiscriminate and disproportionate. The UK now allows those on remand and awaiting sentencing to vote, but does not extend it to all prisoners. Northern Ireland follows the same rules. Scotland has extended the vote for those serving a sentence of less than 12 months, whilst Wales has been considering employing the same 4-year sentence limit as currently exists in Jersey. Ireland has extended voting rights to all prisoners, irrespective of length of sentence, and it did so in 2006. Both Guernsey and the Isle of Man offer full enfranchisement. Prisoners are able to vote by post for representatives of the district in which they were ordinarily resident prior to incarceration. PPC believes it is time for Jersey to make voting available for all prisoners, irrespective of their sentence length. Other changes, as I've said, are mostly administrative and include a revised definition of a spoilt vote, alterations to how candidates' addresses are published if they wish to use an alternative, changes to some of the processes around pre-poll and postal voting, mostly to accommodate the move to a Sunday election, and an extension of the Jersey Electoral Authority's remit to include the consideration of complaints from the public about the elections process and candidates, and also creating a coordinating role for the JEA around the arrangements for hustings. I should point out that there is a typo in the report accompanying the registration on page 5, and that section referencing Article 41 is superfluous, I can't say, as no change is made to that article. So I hope that members will be supportive of these changes to the elections law.
So do you propose Articles 1 and 2 initially?
Yes, please, sir.
Those in favour of adopting Articles 1 and 2 kindly show.
Has the appel, please, sir?
Has the appel been called for? The appel has been called for. In relation to Articles 1 and 2 only of the law, I invite members to return to their seats and invite the greffier to open the voting. I invite the greffier to close the voting, and I can announce that Articles 1 and 2 have been adopted unanimously. 43 votes in favour. Now move on to Article 3. Yes, Chair.
I'd like to take Article 3 separately, please.
Yes. You've said something about it. Do you want to say anything more about Article?
Article 3 is actually the amendment to Article 4, prisoners. And Deputy Jones' amendment is to Article 3, but Article 4 of the law. I got that right? It's getting
Yes,
really
we're concerned with Article
complicated.
3, prisoner voting now. Did I ask if the articles were seconded? I'm not sure if I did or didn't. Were the articles seconded? I said I did, yes. Deputy Miles, do you want to speak about this? You had your light on.
Yes, apologies, sir. I'm just a little bit confused because the Corporate Services Scrutiny Panel did perform some scrutiny on this law, and
Yes.
I'm just a little bit confused about when I'm supposed to stand up and address what the Corporate Services Panel concluded.
Well, you can do so now if you wish to do so. The articles, the principles have been adopted, and we're now looking at the articles on the basis proposed by the chair of PPC. But I think that the way in which she is going to propose them is designed to accommodate the comments that your panel made, because the comments that your panel made were in relation to Article 3, it's called Article 4 in your comments, but Article 3 of this law, Article 5 of this law, and what you refer to as Article 171A, but I think is Article 8 of this law. So the three matters that you address, namely disqualification of certain offenders, electoral complaints processes and hustings, it's most appropriate for you to deal with your comments when the article in particular that you're concerned with is being debated. If that's inconvenient, then you could deal with all the matters you wish to address now.
Thank you, sir, for that clarification. What I thought was going to happen was that I would be able to speak after the Connotab had made her first speech. So,
But she wasn't proposing articles en bloc, just Articles 1 and 2, which are administrative.
but I understand that, sir. But my speech refers to the entirety of P28. So, is it appropriate for me to now deliver the view of the Corporate Services Panel in its entirety?
In the circumstances, yes.
So can I just intervene at this point for what's a point of order, but really a point of direction as well? I presume that the Corporate Services Chair is the main responder in all of these debates. So could you say, it's not clear to me when we break it down by articles, but does that theoretically mean that she can respond in all of the, whatever iterations the Chair of PPC takes it? And of course, that's without a 15-minute limit, not that she would need it.
Yes, that's correct. Yes, Deputy Wilson.
Whilst I'm grateful for your understanding this afternoon, I wonder if you could confirm that this isn't creating a precedent that we can have a speech about the principles after each article. You're simply doing it because of the delay in the debate.
This is not creating a precedent,
Thank
simply
you.
because the principle has been adopted on a previous occasion, and it's convenient, I think, in the circumstances for the scrutiny panel to deal with its observations en bloc, even though the articles are not being dealt with in that way. So it isn't, as you rightly say, creating a precedent. Another point of order, Deputy IO? Do you wish to speak in due course?
No, sir, I wish to speak on Article 3.
All right, yes. Deputy Miles.
Thank you, sir. I apologise for the confusion. I am rising to speak as the chair of the Corporate Services Scrutiny Panel and therefore the main responder to the proposition. As we know, P28 proposes amendments to the election Jersey law with the aim of improving the electoral system in Jersey for candidates, voters and facilitators of election processes. Following the approval of principles of P28 States Assembly, P28 was referred to the Corporate Services Panel for further scrutiny. We've had limited time frame, so we have focused our scrutiny on the primary areas of concern by States members that were mentioned during that State sitting. As members can read, there is a comprehensive comments paper which reflect the observations in respect of those areas of concern. To inform its scrutiny, the panel met privately with the chair of PPC, accompanied by the greffier of the States, and also wrote to the PPC chair and the Minister for Justice and Home Affairs. Just want to make some observations about the three areas. Article 4, which is the disqualification of certain offenders, Article 5, the complaints process, and Article 171A, the hustings. If I can begin with Article 4, the panel observed concern from some States members about reliance on a 2005 ruling, that being the case of Hurst versus the United Kingdom, which concerned a blanket ban on prisoner voting rights as justification for the proposed changes. Jersey does not have a blanket ban on prisoner voting rights and has in place an established legal mechanism to facilitate voting for persons serving prison sentences of 4 years or less. Importantly, the panel has highlighted that the proposed changes to the voting rights of prisoners incarcerated in Jersey are an expansion of the current rules on prisoner voting rights and are not an obligation to ensure Jersey's continued compliance with the European Convention of Human Rights. Whilst the decision to expand the current rules on prisoner voting rights is a decision for the States Assembly, the States of Jersey Prison Service has told the panel that this will have resource implications for the prison. The prison has also confirmed that it was not consulted regarding the proposed changes. And the panel also questioned the justification for not enabling eligible voters who are incarcerated off island from exercising their right to vote in Jersey. In terms of Article 5, the electoral complaints process, the panel also observed concern from some States members about the appeals process for complaints to the Jersey Electoral Authority. Whilst a formal complaints process has not yet been established, the panel understands that the proposed changes mean that in addition to the implementation of a formal complaints process, the Jersey Electoral Authority will also be provided with greater autonomy and an enhanced role in the election process. The panel understands that the aim of the PPC regarding the JEA is for the JEA to emulate the functions of the UK Electoral Commission, and whilst not a complaints panel, the Jersey Electoral Authority will afford complainants a degree of administrative redress. The panel recognises the rationale for establishing a complaints process that ensures complaints are dealt with appropriately, but to improve clarity regarding complaint handling for candidates and the public, this must be managed carefully to ensure it doesn't encourage vexatious claims or create additional challenges for those participating in electoral processes. In terms of the hustings article, hustings fatigue was also raised as a concern by the States members at the last sitting. The PPC has proposed to reform candidate hustings through the inclusion of the new Article 171A in the elections law. This will include the provision of a basic hustings service, centrally managed by the JEA, which will include a venue, equipment and scheduled hustings dates. The panel has raised concern about the absence of an official public list of husting events, which creates additional challenges for candidates, and in particular, first-time candidates. So whilst the proposed changes to the JEA will have resource implications, the PPC has advised the panel and that the JEA will be suitably resourced to discharge its new functions, which they have also been informed of. It was very clear at the last sitting that there's very little clarity about the role of the Corporate Services Scrutiny Panel in scrutinising legislation lodged by PPC. Indeed, this was the reason that I called the legislation in after the principles had been approved. And I thank Deputy Tadier for airing his views on this. To that end, the panel wished to highlight the procedural concerns observed and areas of uncertainty raised by states members about the scrutiny of legislative propositions lodged by the PPC. A lack of awareness amongst states members about the mechanism of scrutiny of legislative proposals lodged by the PPC, myself included, that the referral of legislative proposals by the PPC to scrutiny is highly infrequent. Whether members' concerns could be addressed by the PPC, as well as uncertainty about the role of the States Assembly in holding the PPC to account. The panel has noted that standing orders are silent regarding the identification of a specific scrutiny panel which will be responsible for scrutiny of legislation lodged by PPC. However, the panel's comments highlight the long-standing custom of the States Assembly that scrutiny of legislative proposals lodged by the PPC will be undertaken by the Corporate Services Panel. The panel has suggested consideration to be given to the customary role of scrutiny in relation to legislation progressed by PPC, and that this should more clearly be formalised within standing orders and/or scrutiny codes. The panel has requested that in future it is briefed on all draft proposals that the PPC intends to lodge, and that this will ensure that the panel is at least informed of legislative changes proposed. Finally, the panel has highlighted that consideration and debate of such proposals by the States Assembly is of primary importance to ensure that legislation brought forward by PPC is properly scrutinised and should be the principal method of scrutiny. So it is for the States Assembly to be the principal method of scrutiny for proposals brought forward by PPC. So the panel acknowledges that the PPC has responded to key reports and feedback about Jersey's electoral processes. However, we also highlighted the importance and the need for thorough consultation with all stakeholders about the proposed changes. Thank you, sir.
Thank you, Deputy. Deputy Ayer.
So can I just have a point of clarification?
Yes, Deputy Jones.
Just because the articles are all getting a bit confusing, just to be clear, maybe not necessarily the chair in chair's speech, but maybe when we're going through in the voting, it could be made really clear what we're actually going to be voting on, because just the point, for example, about the disqualification of certain offenders, the switching between Article 4 and Article 3 in different bits of the article is really confusing, and then of course afterwards my amendment is Article 4 as well, and I just want to make sure that everyone will be clear on what they're voting for when, so to make it very clear as and when the articles come up, article.
You're right to raise that, because it is confusing, and the confusion is compounded by the fact that the report itself doesn't talk about the articles in the law, but the articles that are being amended in the main law, which isn't particularly helpful and adds to it. But we'll make it very clear as we go along which articles we're concerned with. And currently, we're debating Article 3 of the law, which deals with prisoner voting. Yes, well, do you want to speak? Because the next person to speak, Deputy Scott, is Deputy Ayer. Do you want to speak on this article, or have you got a question for someone, or your speech in due course? Yes, so Deputy Ayer. Yes, sir. Yes.
Thank you, sir. Sir, I do not believe that Article 4 should be deleted from the elections law. This seeks to remove the provision disqualifying certain persons who have been convicted of an offence from voting in public or parish elections. Not only do I disagree with this suggestion, but I wholeheartedly disagree with the concept of prisoners being given the right to vote at all. In 2001, a case was brought by John Hurst, a man who was serving a life sentence for manslaughter, who argued that the ban on prisoners voting was incompatible with the Human Rights 1998 Act. This was rejected by the British High Court. I believe that we should be following the United Kingdom's approach of a blanket ban on prisoner voting, and I am sure that this debate will highlight the provision of prisoners being allowed to vote to the public at large, and I am sure that it will come as a surprise to many that this is currently the case. We have been informed that 8 prisoners voted in the 2022 election, and a good deal of effort was made to try to encourage others to do so. This seems to me to be a waste of time and resources. I am unaware of any direct engagement or consultation with the States of Jersey Prison Service to determine whether a change to the current system is necessary or supported. And this was referenced by the Chair of Corporate Services just before. How much will it cost to allow a minimal number of convicted prisoners to vote in next year's election? In the report, it states that this will place no additional financial or staffing implications on the administration of the election. But there will need to be supervision and management of visits by election candidates to prisoners, which will undoubtedly require extra resources to facilitate. Those who have broken the law to such a degree that it is deemed necessary for them to be incarcerated should not be permitted the right to vote, since they have shown such poor judgment in being unable to adhere to society's laws. It seems peculiar to presume that they would use good judgment in the selection of candidates standing for election. It is not just the United Kingdom that prevents prisoners from being able to vote. There are other European countries which apply the same disenfranchisement of prisoners. In some parts of the United States, even those prisoners that have been released from jail are still not permitted to vote in presidential elections. That is something that possibly should be considered at a future date. Sir, I would never canvass convicted criminals in prison for their vote, and I would not expect any convicted criminals to vote for me. I will not be supporting this amendment. Thank you, sir.
Thank you, Deputy. Deputy Scott.
So I'll pass on this one. Actually, I'm going to speak on another article. Thank you.
Thank you. Does any other member speak on Article 3? Deputy Lehegaran.
Thank you, sir. It is quite correct in the Chair of the Corporate Services that the prison wasn't asked in relation to this particular matter. But I would say, sir, that it probably wouldn't be appropriate either for the prison governor or somebody within that remit to make that decision either. I think that's a decision for this Assembly, actually. It isn't really a decision for somebody who's the governor of a prison to make that kind of decision. There will potentially be an impact, as it's quietly highlighted from the Corporate Services panel. So from the perspective of the financial part of it, I would ask that if it is decided by the Assembly to make voting more available for prisoners, that is financed by the election and not by the prison, because clearly the prison have significant implications and they are resourced accordingly. I have no objection to allowing other prisoners to vote within our elections. Part of the remit and part of rehabilitation that goes on in the prison is about making good neighbours, and from my perspective, maybe that is actually where we start. Do we actually allow them to vote so that they actually do feel more part of our society? And some of them will, of course, have been voted when they received their prison sentence. So I have absolutely no objection whatsoever to supporting increasing voting rights for prisoners within our prison. However, This cannot come as a cost to the management and the running of the prison itself. Thank you, sir.
Thank you, Deputy. Conataba St Brelard.
Thank you, sir. I'm pleased to follow the last speaker. I took the opportunity in 2022 to attend the prison on my election perambulations, if you can call them that, and the staff were very receptive and enabled my visit with, I think it ended up as 2 particular prisoners who expressed an interest in talking to a budding politician. Whether they voted for me or not, sir, I can't say. They may have stuck with the none of the above, but that as it may be, actually the points they made, I can tell you today, there were 2 significant points made, where one was about housing once they left prison, and the other was finding a job. And those 2 points I've certainly taken on board since, sir. Thank you.
Thank you, Conataba. Deputy Gardner.
Thank you, sir. And I didn't think about prisoners' vote or not vote until I joined election observers mission in the UK it was last July. And I was member of the group that we went to Liverpool to observe election in Liverpool, and our team was the only team that visited prison, because it was first time during the UK elections that they changed the rules, and there were categories of people who were in prison were allowed to vote. And why our mission, our team went to see them, it's actually to speak with the staff and actually engage. It was some prisoners who came to speak to us. It was, and I would like to share this experience. First of all, I would like to explain what are the categories that UK allowed to vote last election. It's not blank ban any longer. So the people who are on remand, awaiting for trial or sentencing, the people who are convicted but not yet sentenced, civil prisoners, imprisoners for non-payment, fines, debts, contempt of court, and also those on home detention, curfew, and released on temporary license can register and vote in the community where they are. The meeting with them was actually touched me. I saw prisoners, and probably the people that I usually I didn't engage with for a long time. And they look at us and they said, yes, we've done wrong. We are here. But I will be released in a year. And in a year time, I'm going back to my business and what's happening with my business. And I hope I'll get back on track, and I hope I will never get back again. But what's happening in country, it's important for me. But the most touchable, it's about, someone said, I've done wrong, but I left my wife, my children, and my wife and my children and my family are influenced for what will happen in the parliament, what decision the politicians will take. And I would like to ensure that my views and which will support my family who stay there and they haven't done anything wrong. I think these things really brought it back to some human reality. And I really would like to emphasize, to support what Deputy Haggerad said. It's not about wrongdoing, it's about rehabilitation. It's about a chance to build a better path. And when we trust people with the right vote, we send a strong message that every citizen's vote is matter, and we need to allow them to come back, that they will feel that they're not completely disconnected and excluded. I understand that some boundaries need to be put in, but including prisoners, what I've learned from that experience, it's very, very strong experience, I think one of the strongest experiences for the Election Observers Mission, including prisoners in our democratic process, we actually reaffirm the value of justice, respect, and believe that change is always possible. It's a difficult one, but this is for members' consideration. Thank you for listening.
Thank you, Deputy. Deputy Ferry.
Thank you, sir. And it's a pleasure to follow the last three speakers, actually, because I myself used to go up to the prison every month on a regular basis in my previous role. And part of what we used to do was prepare people for their rehabilitation. And that word has been used quite a lot in the last three speeches. And what I found was a few things that always stuck out for me. Firstly, people who'd had debt problems, and sometimes they would focus on a very small debt. And I remember speaking to a particular prisoner and asking him, what he planned to do, and he had a whole map as how he was going to pay this small debt off with a telecoms provider. And I finally got asking him to when he'd incurred this debt, and it had been 5 years ago. And on the way out, I spoke to one of the prison officers and said, why do people get so fixated on something which appears so small and wouldn't bother them if they were on the outside? And he said it's very common for prisoners to focus on what may appear quite small issues, give them something to focus on when they come out. So part of what we did was start to create those relationships with prisoners. So when they did come out, they had somewhere, a safe space to come and talk and continue those conversations and that relationship. Now, let's face it, anyone who is incarcerated for a period of more than 4 years has committed a serious crime. There's no doubt about that. But if we seek to rehabilitate as many prisoners as we can, and hopefully not become that revolving door, that can only be a good thing. And I think keeping prisoners involved in the electoral process actually has to be a good thing. It will give people something to focus on, even for a short period of time, and something that they feel that they've been involved with, so that when they come out, maybe they can continue that relationship. And I just think that it would be good to give all prisoners the vote and to allow them to be part of that process. I will be voting for this part of the proposition, sir.
Thank you, Deputy. Deputy Brennan.
Thank you, sir. And continuing the theme of people who visited the prison, I indeed also went to the prison during the election campaign, having been told that about half a dozen people in the prison were willing to speak to me. However, when I got there, I found they'd changed their mind and they didn't want to speak to me. So no doubt displaying impeccable good taste, they had better things to do with their time. Or maybe it was a reaction to the speaking to the constable, who knows? But they'd had their fill of politicians or political candidates. I do think, though, that seriously, this does raise some very, very interesting issues. I think what I find most problematic about the proposition, of the amendment rather, is that there's no case made in the amendment for why we should extend voting rights to all prisoners. The case has been made far more effectively by some speakers in the debate rather than in the amendment. And I would have very much liked to see some discussion about why we should do that, where thresholds might lie, where we might draw the threshold if it's not 4 years. What we've gone for, what the amendment goes for, is a completely allowing all prisoners to vote. But there might have been discussion around extending voting rights to other categories or for longer sentences. And I do think that is a shame, because the issues are quite profound. And the only justification offered in the amendment really is the legal one of the raised by the CPA. And I don't think that is valid with respect, because it was based on a false premise, which is the premise that we had a blanket ban, and we don't have a blanket ban. So it seemed to me that recommendation is a very weak recommendation on which to base such a a significant change in voting rights. I think there's been some impressive speeches by Deputy Gardner and Deputy Ferre asking us to think quite deeply about the issues raised, and they've certainly given me pause for thought in terms of how I intend to vote, and perhaps there will be a few more contributions which can further assist me. It seems to me, about balancing the needs of rehabilitation and making good neighbours with the understandable desire to acknowledge that serious crimes demand serious consequences, and that you are deprived of your liberty when you go to prison, and therefore it may not be unreasonable to also deprive you of other rights that people might have in the outside world, including the right to vote. So this is all about the balance and where that balance should lie, where the balance of rights and responsibilities lie. And as I say, I think it's a shame that there wasn't a much more detailed examination of that in the amendment, because I think it might have helped to clarify some of those issues. So those are my observations at the moment. I'm not exactly sure how I'll vote.
Thank you, Deputy. Deputy Taddeo.
Thanks. So I'll keep it brief, sir, on this narrow point. I think ultimately this is almost one of those that's a vote of conscience. I think members will feel strongly about these kind of issues. It doesn't mean that we can't have rational debates and try and make valid points either way in this. I'd like to perhaps just approach it from a slightly different angle. Is that if our view is one between the two arguments of punishment on the one hand and rehabilitation on the other, I'd say I don't think it's a particular punishment for a hardened criminal to take their right to vote away. They may be somebody who has never engaged in society at all, and saying to them, oh, you know what, we're not going to let you vote, they'll simply say, so what, I didn't vote in the first place and I don't really care about your community. That's not much of a punishment. But of course, there may well be those who are in prison for all sorts of reasons, errors of judgment, perhaps behaviour that doesn't necessarily define them or represent them as people. So I think we need to bear that in mind. I'd say it's probably much more of a punishment if you allow them to vote and allow somebody like me to go to the prison for half an hour and speak to them about why they should vote for me, than if you were to simply say you're not allowed to vote and when you come out of prison, you may not have an appetite to vote. So I'll leave that thought with members. It's not going to be compulsory for any candidate to go up to the prison. What I would say, though, is that I think it's absolutely imperative that when we give any new group of people the right to vote who didn't have that right before, and I think these arguments apply equally to what happened when we gave 16-year-olds to vote. They're not the same groups, of course. But it's incumbent on PPC and all of the electoral system to make sure that those who are gifted the vote also have the wherewithal to cast their votes in a meaningful way, so that they have access to the electoral system. And I would ask the Minister for Home Affairs to make sure that actually, if prisoners are going to be given the vote, then they have reasonable access to voting information, to material, and potentially to those who wish to come to the prison. And I think the interesting question is then, what information do candidates get about which prisoners are in their constituency? And this is perhaps something which ties in with the last debate that we had. So on a practical level, if there are, I don't know, 15, 20 new people in prison who have suddenly got access to be able to vote, will they appear on a special register? A bit like what happens in a care home. We know that there are elderly people who still have a registered home address, perhaps somewhere in the parish, but they're actually registered in that particular care home, and we know that there's a group of people in that particular establishment who candidates can canvass if they want to. Will we be turning up at people's addresses? Will candidates be turning up at an address, knocking on an empty door and saying, oh, that person's not here? Will candidates actually know who's in prison or not? So I think that's something which PPC and the Home Affairs Minister needs to give consideration to. There's also a data protection issue there, but it'd be much simpler if candidates were given a list of those in prison who are in their constituency, so they know exactly who they can ask to see or who might wish to be able to vote for them. So I think those are the main points I wanted to make. The last point I'd say is that, the last 2 points is that the list gets longer. Deputy Ayer said that, of course, we can't trust prisoners to exercise good judgment, but it's not a criteria of exercising your free will to vote to have good judgment. And of course, the question then arises, what is good judgment? It's completely subjective. There's a great tradition in Jersey, which has been going on for centuries, I think, certainly decades, that the public like to come out and exercise poor judgment every 3 or 4 years. And we've seen them do that for generation after generation. And as former Senator Stuart Sivray said, sir, the public ultimately get the government that they deserve. So I think giving a few more prisoners the right to vote, to conclude, isn't going to punish them anymore. I think it's more likely to help them, those who want to rehabilitate, to get involved in the rehabilitation. They may be voting for governments, of course, that will be in power making decisions when they come out of prison and when they're trying to get themselves on the straight and narrow. So on balance, I think I'm quite comfortable to vote for this today.
Thank you, Deputy. Deputy Scott.
So could I please ask a question of the Solicitor General?
Yes.
So the original article, before it's deleted, did mention the position of prisoners who are at large. So what would be the resulting position after the amendment, please?
Yes.
Under the law as it presently is, the convicted person serving 4 years or more is only prohibited from voting during the time that he or she is detained in the prison. So if they're released on licence, they're able to vote. Under the new provision, a detained person in prison will be able to vote where they are entitled to vote in a public or parish election, which means, given what's just been adopted, their names appear on the new electoral register, because they're on the register of names and addresses.
So, sir, just to follow up, so what's the position with escaped prisoners?
That's a good question. I don't know the answer. I would imagine escaped prisoners being unlawfully at large don't have any right to vote.
So can I ask a question of the Solicitor General?
Yes, you may.
I guess on that one, the answer is you just hand yourself in and then you can vote. But it might be too much of a price to pay to be able to vote for Deputy Ayer in St Helier or where. But so the question is, so the question is whether or not where the names will appear. So all these new prisoners who are going to be registered to vote are on the electoral register that's available to candidates. Will it show an address at the prison, or will it show an address at their former address where they used to live just before they got incarcerated?
You can answer that one now, can you?
Well, I'm not sure I can. I'm not sure it's actually a question of law. I don't know how necessarily it will work in practice. All I can say is what the amended law says, which is a person detained in prison is entitled to vote if they're entitled to vote in a public or parish election, which means that their name appears on the electoral register as being at a particular address. I don't anticipate that means the prison address. I anticipate it means the address of the constituency or ward in which they were living when they were at liberty. And I was slightly flippant in my response to Deputy Scott's question. I didn't mean to be. The answer, sir, is I genuinely don't know what the law envisages about prisoners who are, as it were, on the run within the island.
Yes, Deputy Scott, another question?
Yes, sir, I think this just illustrates a concern about the process, and following up on something that Deputy Tadier said earlier about the...
You asking a question or making a speech now?
I'm making a speech, sir. I'm just in the...
All right.
In the context of actually what we're doing right now, which is scrutinising legislation, and we've talked about, we have scrutiny panels that scrutinise most legislation. We recently have found out or had established that the CSFP would have this role, and yet there seems to be the suggestion that we, the States Assembly, should be scrutinising this legislation and only us. I would say that actually I don't really agree with that. In an ideal world, what we would have had, just as I've requested with other legislation, is a black line copy if we were going to scrutinise so that we're really clear about what we were approving and the consequences. So as this debate continues, I think that I have this kind of discomfort. But in the case of this particular provision, there are some other options I just wondered about, unexpired sentences, in terms of the period of rehabilitation. Deputy Renouf has actually referred to the basis on which this particular amendment was brought by the PPC in response to something by the CPA that was mistaken. So I don't find this the most, the most satisfactory process personally. So I won't support this particular provision.
Conor of St Mary.
Thank you, sir. And I begin by saying that I was in the Assembly at the time of the vote, which voted against the blanket ban and introduced the 4-year limit, as it were. And I confess or claim that I voted against that relaxation on the basis that within that 4-year penalty, you could have committed a fairly serious crime. And I felt at the time that the gravity of the situation was such that you should not be allowed to vote. If that vote were taken again today, I would actually be inclined to agree with the 4-year relaxation. And I say that from the point of view of rehabilitation. I'm not sure it's coincidence or convenience that the 4-year period coincides with our election cycle. And it therefore means that anyone who is committed to prison for 4 years is going to be able to vote in the next election, which brings me on to the question of rehabilitation. And in that connection, I take on board the points made by Deputy Ferry, and I can see the advantage in pursuing a rehabilitation procedure. But question, should that be for everyone, or why should it not be for those whose period in prison is going to terminate within 4 years? So in short, I would have preferred a greater degree of consultation on this matter, and I would be inclined, had an amendment been brought, and yes, I should have brought it myself, that would have allowed those whose period expire within the next 4 years to be allowed to vote, because that would assist their rehabilitation procedure. But as it stands, I remain against the blanket relaxation. Thank you, sir.
Deputy Joseph.
Thank you, sir. I support this article and will briefly explain why. Its intent is to extend the right to vote to all prisoners in Jersey. Arguably, there was a muddle. Now there is a model, which is proposed by PPC. Under the existing law, it seems that serving prisoners longer than 4 years disqualified. That doesn't feel right. This threshold is being removed upon advice by the CPA. We either take their advice seriously or not. It was regarded as the Constable of St Mary as I think, a compromise intended to uphold seriousness of long offences whilst complying with some human rights obligations. Voting is now extended to be extended to all prisoners. Voting will incur by postal vote, I note. An ECHR measured step that recognises that the right to vote is not a reward for virtue, sir, but a basic democratic entitlement. Civic inclusion can and always does support rehabilitation, and that's what I think this is about. Of course, corporate services have rightly noted that the prison service was not adequately resourced or consulted. They maybe should have been. But I do not believe that that's a reason for us to vote down this article. I do believe that government must now ensure that PPC has and the prison service has the right resources, systems and clear guidance that will put in place so that we can deliver upon this promise, well, not just in law but in practice as well. So I would like to see the inclusion for all prisoners. That's part of them being rehabilitated. I know that prisoners do bad things. That's why they're there. But they need to be rehabilitated and they have a right, as we all do, in the democratic process. And I think that that should be a strong signal for rehabilitation to say that they're in prison, but we want them to be out of prison and members of society that are included. And we have got rehabilitation of offenders and all the rest of it. So I see well done, PPC. They've listened to the advice from the international observers, and we've got the right systems. It's possible to implement it properly with the right resources, which I'm sure government will respond to. Thank you, sir.
Thank you, Deputy. Solicitor General, you have some further advice for us?
So yes, thank you. I wanted to clarify what I said earlier, and I apologise for not thinking about it more carefully when I was first on my feet. It's just about this question. I'm not sure what much turns on it necessarily, about a detained prisoner who is in fact unlawfully at large on the run. Are they enabled to vote? The effect of Article 4A1, the substituted 4A1, it seems to me is this: if they are unlawfully at large, but they're entitled nonetheless to vote in a public or parish election because their name is on the register, then they are entitled to vote. They may put themselves at jeopardy of being arrested if they turn up at the polling station, but that's a different matter. They would still be entitled to vote applying the law on its face. I hope that's helpful.
Thank you. Yes, Deputy Gorston.
Thank you, sir. I know Deputy Tadea said that maybe this is a matter of conscience, and indeed maybe it is. For my part, as the Conitop of St Mary reminded us during the initial debate, there were a number of proposals brought forward. I don't, as I stand here, see that the case has actually been made. I understand the position of PPC. They've had an election observers mission report. They've made a suggestion. But for my part, I'm clear that our current approach of prisoners who've got a sentence for under 4 years are able to vote currently. Those over 4 years aren't. And the reason I think it's interesting is because I can't recall entirely the nationality or the jurisdictions that those election observers came from when they came to Jersey to observe our elections, but I think there was certainly some from the United Kingdom and the devolved administrations. And as we know, they have a system in place which is less favourable to prisoners than ours. So I don't think that the case has been made. Of course, it is important that we think about prisoner rehabilitation, but as the Conitap of St Prelard's reminded us, they are issues around jobs. They are issues around housing when they come out of prison in order to re-emerge into our community and feel supported and feel that they've got provision. Of course, Deputy Tadea said that a hardened criminal probably didn't vote before they went into prison, so it's no great benefit for them to be able to vote in. Of course, we can take the opposing view, of course, which is therefore it's no great rehabilitation for them to be given the vote. So we can argue that case either way. But as we stand here, I understand why PPC have brought forward this change, but I don't believe that the case has been met, and therefore I will be voting against Article 3 to remove Article 4. Thank you.
Thank you, Deputy. Yes, Deputy Balash.
So as a general rule, it seems to me people are entitled not only to their freedom, but also to all civic rights which go with that freedom. But when people commit very serious offences and are sentenced to a long period of imprisonment, it is arguable that they forfeit not only their liberty, but also the freedom to exercise civic rights, and in particular the right to vote for members of their legislature. The Court of Human Rights held that a blanket ban on prisoner voting was a breach of the Convention. Was a breach of the Convention. I don't think that the election observers were correct in describing our decision to allow only prisoners serving less than 4 years imprisonment to vote as a blanket ban. It was not a blanket ban. It was a decision which struck a balance, and I think it was a fair balance.
murderers, rapists, and others who commit very serious offences and take away other people's rights to life or respect for their physical integrity, forfeit, in my view, not only their liberty, but also their rights, at least for a time, to participate in the activities of civil society. If you behave in an uncivilized way, it should not be surprising that some of your civil rights are taken away. Prisoners who are sentenced by the superior number to sentences of 4 years and more should not be entitled, in my view, to exercise voting rights. I think the balance that was struck 10 years or so ago was correct, and I don't think that this particular amendment should be supported.
Thank you, Deputy. Does any other member speak on this article? I call upon the Chair to reply.
Thank you, sir. Firstly, I'd like to thank the Chair of the Corporate Services Scrutiny Panel, Deputy Miles, and say that I've taken on board what she has said and what she said in her comments paper. Just to say that the Jersey Election Authority is devising a policy for complaints, and as this is an important aspect of their role, they're making certain that the process is robust, especially as it occupies so much of their time in 2022. PPC is happy to provide, and PPC is happy to provide a list of its upcoming legislation to scrutiny and is grateful for its review. Deputy Ayer, who's a member of PPC, he's very aware, but I should say to the Assembly, that, and this was brought up by Deputy Scott, the reason this has come before the Assembly is that this issue is a recommendation, but the PPC was not unanimous on the issue of prisoner voting, and so we decided to leave this to the Assembly to determine. Deputy Lehegere, with regard to prison votes, we were told this would result in an additional 37 votes if passed based on the March inmate levels. And all prisoners vote by post at present, and there's no expectation that this would change. And we're not sure what additional resource implications this would be if it's purely postal voting. Right, see, Deputy Reniff. As I said before, the committee have been divided on this, and so we wish the Assembly to make the choice. And the wording in the EOM recommendation explicitly refers to the 4-year limit. I think Deputy Tadyer asked about what address they would have, and it's where they lived before they were incarcerated. Thank you to Deputy Ozef. I have got something else to say, and to Deputy Scott, I hope she doesn't mind me saying this, but if only the public were so keen to vote that they would break out of jail to do so, PPC hopes that the changes will encourage voters, but not to that extreme. So I'd just like to read out, as I've been asked to make it more explicit to everybody what they're voting for. The Election Observers Mission, Article 3 of the Amendment Law, the Election Observers Mission Recommendation 4 from 2022 stated that to allow for broader electoral participation on an equal basis, the blanket ban on the right to vote for persons serving prison sentences exceeding 4 years should be removed. The committee wishes to extend the vote to all prisoners based in Jersey. This article deletes existing Article 4. As previously stated, this will bring us in line with our Crown Dependency colleagues. PPC is determined that there are wide perceived benefits of extending voting rights to all prisoners, including the creation of social ties and a commitment to the common good, and therefore wishes to remove the disqualification limit, extend the vote to all prisoners, and offer them postal votes to allow them to participate in elections in the constituency in which they resided prior to being detained. The numbers for this are not huge, and as I've said, we were advised that had this been applied in March, it would extend the vote to an additional 37 inmates at Lemoy.
Do you prepared to give way? Just a point of clarification?
Yes, sir.
Prepared to give way? Yes, Deputy Tadia?
Thank you. I wanted to wait till the end of the speech, but I think we're almost there. So could I ask the Chair what the process is for prisoner voting? So I'm mindful in passing this. If they registered at their home address before they were in prison, how do they physically vote?
Chair.
I do know that it's the only information I do know is that it was at their previous address, and they do have a postal vote, so I presume that it would be forwarded to the prison for them to vote, or the prison officers would have some way of arranging the vote for them, the postal vote for them.
Is the appel called for?
Yes, sir.
Appel has been called for. Members are invited to return to their seats. I ask the greffier to open the voting. If all members have the opportunity of casting their votes, I ask the greffier to close the voting. I can announce that the article has been adopted in second reading. 28 votes for, 15 votes contra, and 1 abstention.
May we have the 15 and the 1, please?
Yes.
The Connotab of St Martin abstained, and those voting contra, the Connotabs of St Lawrence, St Clement, Grouville, St Mary and St Saviour, Deputies Labby, Ayer, Gorst, Moore, Balash, Miles, Scott, Renouf, Alex Curtis and Barbara Ward.
Chair, do you propose Article 4?
Yes, sir. And Article 4 of the Amendment Law is a criteria for entitlement to be registered. This amendment simply makes a minor amendment to the wording of the law to ensure consistency in approach when referring to someone being ordinarily resident. There's an amendment to Article 4. PPC does not oppose this amendment, but would prefer the Assembly to determine whether it wishes to extend eligibility to those who have only been resident for 1 year. I'm advised that it should not be problematic to work this into the automatic voter registration programming, and it clearly will increase those on the register, be more inclusive and send a strong message out to the public that we value the views of everyone who makes Jersey their home. Thank you, sir.
Is Article 4 seconded? There is an amendment to Article 4 lodged by Deputy Jan. I ask the greffier to read the amendment.
Article 4, substitute. Article 5, entitlement to be registered, amended. This article amends Article 5 in paragraph 1C1 for 2 years, there is substituted 1 year. And in paragraph 3A, for becomes resident, there is substituted becomes ordinarily resident.
Deputy Jan.
Thank you, sir. I ask for members to support this modest but meaningful amendment to Article 4 of P28, which would make an amendment to Article 5(1)(ci) of the Elections Law, one that seeks to reduce the residency requirement to vote in Jersey from 2 years to 1. I hope members can see this is about strengthening democratic inclusion and not lowering any standards. During the last election, knocking on doors, I met islanders who were fully engaged in the issues we debate here and what issues islanders want us to debate here. Sometimes these may not be aligned. These are people who live and work in our communities, pay taxes, social security, rates, already volunteer for scouts or community sports or charities, are engaged in Paris and community life and starting to care deeply about Jersey's future, a future they could see themselves and their families being part of. They were invested, but they could not vote. The law told them, you don't belong, not yet. I believe that denying them a vote while expecting their civic participation elsewhere is inconsistent and disenfranchising. So this amendment seeks to right that small but important imbalance. Many of us in this chamber have talked about how to encourage people to integrate, to get more involved in our community, to take part. But this current law tells them, not yet, wait. And in many cases, that early enthusiasm, while getting to know and understand their new community they've moved to, settling into their new home, could fade. People could feel shut out, disconnected, A 2019 study in the Electoral Studies found that earlier voting access increases political participation and social cohesion among migrants. And Jersey relies on migrant labour. The stability of Jersey's working age population has relied heavily on this inward migration. According to Statistics Jersey, around 3,700 people immigrated to Jersey in 2022, with net migration that year recorded at about plus 200. In 2023, net migration increased to plus 470. While full immigration figures in 2023 are not yet published, if proportions were similar to 2022, it's reasonable to estimate that approximately 4,200 people may have moved to Jersey in 2023. Although not all may be eligible to vote due to other criteria, many would have been able to. And as an example, many of those would have moved from the UK, would have been British, and anybody from Jersey who moves to the UK, they are automatically entitled to vote if they can prove residency, but yet here they would have to wait 2 years. If our economy and essential services depend on these people from the moment they arrive, why shouldn't they also be able to participate in choosing the State's Assembly that shapes the politics affecting their lives? These are engaged, invested residents, professionals, key workers who want to be part of Jersey's democratic process. Denying them that right for 24 months risks alienating them at precisely the moment we should be encouraging their integration. I believe 1 year of continuous residency is enough time for a resident to demonstrate commitment to this island. The proposition filters out transient populations while still welcoming committed new residents. It's a standard already reflected in other jurisdictions like the Isle of Man, who has not seen a destabilising effect, and aligns with the recommendations from the 2022 CPA, Commonwealth Parliamentary Assembly Election Observation Mission to Jersey. And some may worry this change is too much or wouldn't make a difference. I would argue that giving someone, even one person, or one family, a stake in our community, it's sooner rather than later, fosters that belonging and it deepens the roots. Democracy is not a zero-sum game. Expanding the franchise ensures more balanced representative decision-making. Everyone living and contributing here should have a say in shaping Jersey's future, regardless of whether they've been here for 1 year or 30. Long-standing residents' views remain vital, but they should not come at the expense of silencing others who are equally affected by political decisions. So this amendment is simple, it's fair, it reflects the lived reality of many people who already call Jersey home. So I ask members to consider, if someone contributes to our island from day one, why must they wait 2 years to have to say and how it's run? Democracy isn't a probation period, it's a partnership. I therefore encourage members to support this amendment. Thank you.
Thank you, Deputy. Is the amendment seconded? Does any member speak on the amendment to Article 4? Deputy Scott.
Thank you, sir. I think that inclusivity is very important when it comes to understanding different viewpoints, particularly in producing policy and indeed in reviewing policy. But I also think that experience is important too. And I think that's the balance that one needs when it comes to having people participate in the voting process. Now, I remember when I came here as an immigrant many years ago, and I worked in a law firm, and my qualifications, even though I had worked years as a relatively senior lawyer in the British Isles, I wasn't actually recognised in this own jurisdiction. I had to requalify. I wasn't even allowed to take the exams until I'd been here for 2 years. And actually, during that time, I learned a lot about the way things are in Jersey. And of course, that old joke, I guess people don't use this anymore, about there being a boat in the morning, if you didn't like it. We still do, all right. And yeah, you just would laugh about it. But there was a certain truth in that. There was a certain, well, okay, you know, but you can vote with your feet for now. And that is an option. I don't think it is actually something that we particularly want, but it's something that we should always be mindful of when it comes to those who come to our community as immigrants. I personally feel uncomfortable about agreeing to this amendment at this time, particularly with the introduction of automatic voter registration. I think that it's important to just see how things work, what the impacts are, and just be mindful as you know, if one wants to go along this journey. So I'm not convinced about supporting this amendment at this time. Thank you, sir.
Thank you, Deputy. Deputy Alms.
Thank you, sir. I think I'm probably in a very unique position in this Assembly as one of the very few people that can vote in two jurisdictions at the moment. So I'm a Portuguese citizen as well as a British citizen, and as a result, I get a ballot paper posted to me when it is the Portuguese Republic elections. Now, so I've never lived in Portugal. I've never lived in Madeira. I actually don't get a right to, my family are from Madeira, I don't get a right to vote in the Madeiran elections, but I do get a right to have a say over the government, the main Portugal government. And so I think that's really important, that although I haven't contributed to the economy in Portugal directly, maybe indirectly, by obviously going back on a number of occasions, and as much as I can, I do have a stake in Portugal because, and much like some of the contributions mentioned in the last article that we debated, my family are there, and that does impact what happens in the country, does impact my family. It also impacts my possibility if I ever want to go and live there. But I have never actually lived there, and I have never actually economically contributed to Portugal. But I think it's really important that I have that right. And I think it's really important that actually anybody that has a stake in a community that they belong to, whether that's through citizenship or through actually being in that country, contributing, has a right to have a say in that. So, so I think, I also kind of maybe swaying a little bit, but I actually think it's a shame that if I were to leave Jersey, for example, I would not be able to have a say in the same way that I do with the Portuguese elections, in the Jersey elections, because actually, you know, my family could still be here, and I was born here, and I've lived here all my life, but yet if I was to go and then return again, I would lose those rights, and I would have to wait 2 years under this amendment. It would be 1 year. So actually, sir, I think it's really important that we recognise that if somebody has a stake in a community, that, and this amendment actually is reducing the requirement of the 2 years down to the 1 year, I actually think it's a shame that we're not going further and allowing people to, who are Jersey people, if you like, and probably because of the absence of a Jersey citizenship qualification, or whatever you want to call it, that we don't allow those who have left the island to still be able to vote. This is definitely a step in the right direction, and this is the right thing to do. So, sir, I will be supporting this, and I hope that others will as well, and I hope that we send out the message that we recognise the importance that people coming to this island provide our island with, you know, that they have to pay taxes, they have to pay social security, all of those things. So I would urge members to vote in favour of this. Thank you, sir.
Thank you, Deputy. Does any other speak on this amendment? Deputy Joseph.
So I'm sorry that other members aren't going to speak, and I'm sorry if I'm appearing like a jack-in-the-box, but these issues are really important. I actually, and this is an example where part of the day one can be absolutely against a certain group of individuals, and I'm looking across at Reform, but we are actually unifying other things. That's one of the beauties of this assembly and the beauties of our island. I heard the former bailiff, when he was giving a liberation speech, talking about Jersey and the definition of Jersey people and the tapestry of peoples that we are. My late father, sir, thought it was very amusing that he was regarded as such a Jerseyman, as he looked up at a wall of a picture and said, my great-grandfather was a fils français catholique. It was an alien. And such is the discrimination that did exist against Catholics and French and Norman immigrants. But times have changed, and we need to welcome people of all sorts of different nationalities. And if I may say, sir, the actual numbers of people that do come and work here and that are here for 1 year, many of them are in our caring services, sir. Many of them are in the hospital, doing a terribly difficult job at both the consultant level, the nurses level and others. And those people, and I met a policeman the other day, and he was just over from the UK, came from Essex, excellent individual, working in our police force. And I thought to myself, why can't these people, they're serving Jersey, and they are working very hard, they're paying their taxes, why can't they vote? Why can't they actually have a say in the democratic decisions that are encouraging us to do things like build hospitals or otherwise, or pay decent salaries? And I think it's absolutely right, sir. We've always been a welcoming, open community. We do have, sorry, I put my hand in my pocket, sir. Do you reckon you would have shouted at me, sir? I shouldn't do that. It's not respectful. Sorry, I kept my hands there. I have to remember these things, sir. So the respect that we should accord our people that pay taxes. If you're ordinarily resident, surely you should be able to vote. Surely, if we ask people to pay their taxes, they should be able to vote. And I purposefully use care workers, people that work in the hospital. They take an interest in our island. We do allow people in Jersey, unlike other places, who don't have British citizenship, as the last speaker said. And that's a peculiarity of Jersey. If you're in here, yes, you certainly need a British passport, sir. You need to be able to do your allegiance to the Crown. But if you are a voter, I think that if you're basically coming here to work, and my goodness me, it's very difficult to come and work here these days, sir. It's very difficult to get a job that you can stay here for more than 9 months because of the work permit system that we had inflicted on us by the last but government that basically brought in the UK law and just plonked it in Jersey and said we had to subscribe by it. It's jolly difficult. And so actually, we need to basically go out and say we do need workers. And we do need workers that are actually going to stay for more than 9 months. We want them to commit to Jersey. And at the moment, we've got this transient throwaway culture of people that we accept into Jersey and then throw them out because they've been here for 9 months under a work permit system, which I have to say I don't agree with. So actually, if you're here for more than 12 months, you should vote. And I think the Deputy is quite right to bring that. And I hope that other members will send out a very clear message that if you pay your taxes, if you're ordinarily resident, and if you're working, think about that nurse, that person who's working, caring, working really hard for Jersey. They're here out of choice, and they should be able to have a say in our democracy, so after 1 year of residency, and that presumably means paying their taxes. Thank you, sir. I support Deputy Chair, and I know that other members might not like it, but I want Jersey to be an open, welcoming place, sir, as it always should have been. And today, maybe it wasn't always, but now it should be. And I think it should be welcoming. If you're good enough to work here, you're good enough to have a rental agreement, and you should be good enough to vote. Thank you, sir.
Thank you, Deputy. I call upon Deputy Jones to reply. Deputy Jones.
Thank you to all the members who have contributed to this vote. I think democracy, take a few points, again, that I kind of highlighted in my beginning speech and those that have been mentioned by members, but democracy is grounded in the principle that those who are governed should have a voice, and people who live, work and pay taxes should have a say in the rules that govern them. And I believe widening the franchise, broadening who can vote is vital for any healthy democracy, especially in a small community-based jurisdiction like Jersey. And I just want to say to Deputy Alves, I'm also one of the few privileged members here who can vote in a number of, as well as Deputy Kovac, in other jurisdictions, and one that I would actually be fined if I didn't vote in Belgium. But I'm happy for that. I'm happy to vote, and for that I'm happy to vote for the European elections as well, because I'm proud of being able to vote. I'm proud to be part of the different systems that I am and linked to, and even if I have left the European Union physically but not in my heart, and then also Belgium again physically but not in my heart, I still very much feel that I am part of that democratic choice, and I think that is important coming to Jersey, that those people still feel the same, that they are included, and it builds a stronger legitimacy for the election outcomes. We are not talking about a huge number of people, because of course those are the people that will be 12 months after, within 12 months of their arrival when the election happens, which every 4 years. We are not talking about huge much, just like we weren't talking about a huge amount just before when we voted for the prison population. But I believe every vote counts. I believe everyone should be entitled to that, winding the franchise and to bring them and motivate people who arrive in this island to engage, to integrate, to invest in the community, to welcome those newcomers to our island. We need to build a culture of participation. We still haven't got it right. I believe we recognise that we haven't got it right, and this is just a small amendment that would help those who want to vote to be able to vote after 12 months. Thank you.
Thank you. Is the appel called for? Yes, sir. The appel has been called for. Members are invited to return to their seats, and we're voting on the amendment to Article 4 lodged by Deputy Joan, and I ask the greffier to open the voting. And if all members have the chance of casting their votes, I ask the greffier to close the voting. And I can announce that the amendment has been adopted. 30 votes pour, 16 votes contre. Yes.
Those voting contre, the connotables of St Lawrence, St Brallard, St Mary and St Saviour. Deputies Labby, Luce, Gorst, Moore, Balash, Scott, Binet, Howell, Binet, Ferry, Barbara Ward and Deputy Andrews.
Now return to Article 4 as amended. Does any member wish to speak on Article 4 as amended? If no one wishes to speak on...
Sorry, could we just confirm, this is the amendment, confirm where this is?
Yes, we are considering Article 4, which was proposed by the Chair. Then there was a debate on the amendment to Article 4 only by Deputy Joan, and we're now returning to Article 4 as amended. Do you follow?
Yeah.
Do you wish to speak on it? Yes, Deputy Ward.
So I believe this is the one where the articles, is this the articles talk about the hustings and the polling stations?
No, we're not on
That's
there.
why I asked,
We're
because I thought
just
I was
talking about a
confused.
single article.
I'm sorry, sir, I was away on an appointment.
No, it's easy to get confused.
That's
about
okay,
this.
thank you. At least I'm honest about it.
Yes. Good, yes. So Article 4 as amended. Does anyone wish to speak on Article 4 as amended? It may be that no one does because we just had a debate on the amendment, which effectively is Article 4. Are members content to adopt Article 4 as amendment, or is the appel called for? The appel is called for on Article 4 as amended. I ask the greffier to open the voting. Members are now voting on Article 4 as amended. All members have the opportunity of casting their votes. I ask the greffier to close the voting, and Article 4, as amended, has been adopted. 36 votes pour, 8 votes contre.
Can we have the 8 votes against, please, sir?
Yes, of course.
Those voting contre, the Conotub of St Lawrence, Deputies Labby, Gorst, Scott, Rose Binet, Howell, Tom Binet and Deputy Andrews.
Chair of PPC, how do you wish to propose the balance of the articles?
So I would like to propose Articles 5 to 17 en bloc, but I would like to read out an explanation for each one, and I don't believe any are controversial, but Article 5 of the Amendment Law, Resolution of Disputes. During the 2022 election period, the JEA dealt with many complaints, but the scope of what was limited by Article 13 of the Elections Law, which provided that the JEA could only accept those made by a candidate and could only be about another candidate or an individual carrying out election functions. The JEA received many inquiries which were ineligible for consideration under these terms, but would be classed as complaints in the ordinary meaning of the word. Themes covered by these inquiries included election material and its citing, use of social media and comments made at hustings. The JEA said in its report, the JEA believes that its role in dealing with disputes needs to be reconsidered. The Election Observer's Mission Recommendation 12 stated, in order to bolster the system of election dispute resolution and make it more inclusive, consideration should be given to the establishment of administrative redress available to persons other than the contestants. This article extends to the resolution of disputes by the Jersey Election Authority. The JEA was still in its infancy when the last elections were held, and it struggled to define its role in the short period leading up to election day and meet the expectations of the public. Extending the JEA's complaint handling jurisdiction will align better with the remit of the UK Electoral Commission, on which the JEA's role is based. And this time, there will be sufficient need in time to publicise clear guidance regarding the functions of the JEA and make it explicit what they will and they won't adjudicate upon. Thank you. Article 6 of the Amendment Law, when oaths are taken. This article simply fixes a time frame for newly elected members' oaths to be taken. Article 7 of the Amendment Law, nomination forms content. This is a minor amendment. At present, this article allows candidates to provide an alternative address on their nomination form and to specify that their home address should not be made public. However, when the poll is announced, this includes their address, and this amendment simply ensures it is that alternative address which will be published. Article 8 of the Amendment Law, new Article 17.1a, hustings. This is a completely new article to manage the hustings process for 2026 and onwards. In 2022, candidates and the public reported hustings fatigue, with some candidates attending multiple events on successive nights across constituencies. There were problems when clashes occurred or candidates had prior commitments and therefore could not attend an event, as they were worried this would appear to the electorate that they were not as dedicated as their counterparts. This new article places the coordination and management of the hustings with the JEA rather than with the candidates. It will ensure the events can be scheduled to avoid clashes, which will make them more accessible to the public and also reduce the associated cost of having to film multiple events on the same date. It is proposed that the JEA will provide the dates before the nomination period so that prospective candidates are able to plan for them and ensure their availability to attend. Articles 9 and 10 of the Amendment Law, notices in the Gazette. These amendments are to accommodate the elections moving to a Sunday. Article 11 of the Amendment Law, ballot papers. This amendment expands the requirements for the content of a ballot paper so the JEA could allow photos of candidates if deemed appropriate. Article 12 of the Amendment Law, polling stations. The EOM's recommendation 9 stated, the number of voters per polling station should be reviewed to ensure polling stations are in close proximity to voters' residences and or easily accessible via public transport, and to ensure that polling stations are manageable if many voters turn out on election day. The committee considers there should be greater flexibility as to where polling stations are located to ensure they are placed in the optimum position for voters. This amendment simply places the decision as to where the polling stations should be with the JEA in consultation with the authorities. Article 13 of the amendment law, candidate information. This amendment allows for information about candidates to be made more accessible within the polling station. At present, there is a requirement to have the photos and names of those standing on display. This addresses accessibility issues to allow for reasonable adjustments like large print or translations. Article 14 of the amendment law, giving ballot paper to elector. In 2022, voters reported being asked if they wished to vote in both the deputies and constables elections within their constituency parish. This caused some confusion, and the committee is keen that no voter is disenfranchised from casting all of the votes to which they are entitled. The JEA suggested that this need for questioning be removed from the law. Article 32A will be removed so that electors will be given ballots automatically for each of the polls taking place. It is a matter for them if they subsequently choose not to cast all of their votes. Article 15 of the amendment law, assisted voting home visits. This amendment ensures that requests for home visits for islanders to cast their votes on election day itself are available only for those who find themselves unable to vote on election day, as they had intended to, due to unforeseen circumstances. Home visits require 2 members of staff to be sent to a person's home to take their vote, and this amendment limits access to those who could not reasonably have known that they needed to apply for a postal vote instead. Article 16 of the amendment law changes reference to spoilt ballots. This is an administrative amendment to ensure consistency. This amendment follows on from the change to the definitions in Article 1 and substitutes the word spoilt for cancelled, which is the generally understood definition. 19 Article 52A, result in public elections or parish elections, amended in Article 52A, brackets 3, brackets A, for spoilt. There is substituted cancelled. The intention is to help with the completion of the returns form by the authorities. Article 17 of the amendment law.
Sorry to stop you there, but
Sorry.
I think Article 16 contains the word annulled, not cancelled.
Oh,
I think
sorry,
there's perhaps a spelling mistake in the report. Sorry to interrupt you, but just to...
No, thank you. So, for sport, this will be substituted annulled. The intention is to help with the completion of the returns form by the authorities.
Yes.
Article 17 of the amendment law, procedure for postal voting. This change makes the deadline for the return of postal votes several days earlier than election day. This is required if postal voting increases in popularity, as it will ensure that there is sufficient time to process the envelopes returned. It is also of particular importance if there is an agreement, as there is an agreement for elections to be held on Sunday, as there's no postal delivery at the weekends in Jersey. This change will require postal votes to be received 2 working days before the poll. I hope that members will support these administrative changes to the elections law, and I call for the appel. Oh no, sorry, I don't. I have to, yes, sorry.
Maybe soon.
Sorry, it's been a very long afternoon, sorry.
So may I ask a point of clarification?
Well, before we do, are those articles, yes, you must ask now, yes.
Just on the last bit, may I ask the Chair of PPC, with the postal voting, is it received, the date it's actually received, or the date is posted? That is the important thing. I just want real clarity there. And how is that recorded as being received? Is it dated by who? Because it looks like you'd have to open the ballot paper to see it's there, or will it be inside an envelope? I just want to be clear. I'll speak about it when I speak, but just to be clear, thank you.
Was that now or later on? Yes. So point of clarification?
Yes, sir. Before this is seconded, unless I missed it, I wasn't aware members had been asked if they were content that this would be taken on block. I think it was. So, I mean, I would have interjected at that point, sir, and requested that Article 5, the next one, would be taken as a separate vote to allow separate debate. I don't believe members were asked whether they were content with the remaining articles being on block, as well as what the proposer wished to happen. Thank you, sir.
Yes. Well, in that case, we'll have a separate vote on Article 5 in any event, as requested. Are these articles seconded? Yes, sir. Yes. Conrad St Lawrence, is your light on?
Yes, sir, to speak.
Yes. Do you want to speak now?
Yes, sir, happy to do that. Thank you. I'd just like to have clarification.
Just to be clear, if we're having a separate vote on Article 5, then we need to debate Article 5 first. So any speeches must be focused on Article 5 in the first instance. So, yes, Deputy Scott.
Sorry, are you saying that we vote on Article 5 just to have it debated separately? Okay, thanks.
Yes, in order to avoid confusion, there's no difficulty with the procedure that we've adopted so far. We'll have a general debate on Articles 5 to 17 and then a separate vote on Article 5. That's what we'll do. Yes, so do you want to speak to the articles as proposed?
Sorry, sir, you're addressing me, yes. Well, actually, I had a question for the Solicitor General again.
Yes, all right.
Just with this particular article, which enables people to make complaints to the JEA, which doesn't have its own review body. So I suspect that the recourse, if people aren't happy with the way it does things, is judicial review. So I'd like that confirmed. But also, quite bearing in mind that it's suggesting that things like that the law suggests that the JEA monitor conduct and produce a code of conduct, the terms of reference, where exactly are they, to be clear that this is all in support of fair elections rather than, you know, perhaps more extraneous details about conduct.
Is that a question you want to respond to now?
No, I don't start time, please, thank you.
Yes, all right. Conrad St Lawrence.
Yes, thank you. So I'd just like to refer to Article 26, if I may, polling stations. Am I able to do that now, sir, or are we still speaking to 5?
No, we're speaking to Articles 7 to 17, sorry, 5 to 17 inclusive, and that does cover the amendments to Article 26, because that's Article 12 of the amending law. So you can address polling stations now if you wish.
Thank you, sir. So we know that the authority in consultation with the JEA will be able to decide whether the polling station that the parish suggests for use is sufficient or not. So all parish halls are used as a polling station. In my parish, sir, we have had the debate for some years regarding the top of the parish, where the parish hall is, and the lower part of the parish, i.e. the Millbrook area, which is well built up residentially, and whether people should be able to have should there be a polling station at the bottom of the parish. So my question to the chairman of PPC, sir, is if it was deemed that a polling station should be used in the lower part of the parish, as well as the parish hall, and it was a building that is used commercially, and there would be a charge for its use, who would be liable to pay that charge? I haven't heard of anything that addresses that, sir. Not sure that it's going to happen, but if we approve this, then it's likely that it could happen and there could be a consequent charge. So does the parish pick up the tab? Is it covered by expenses that can be given to the parish, sir? I'll just leave that, thank you.
Thank you, Conrad. Does any other member to speak on Articles 5 to 17? Deputy Rob Ball, then Deputy Alex Curtis.
Thank you, sir. Just a few points to make. I've lost track of which articles are which here, sir, so I'm not going to quote the article numbers, but I'm going on the speech that was said, so we'll let's go
Do you want us to help on that? Because the confusion is because the report uses the articles of the law we're amending, but the law itself...
Thank you, sir. That's exactly the confusion I'm having.
Well,
I feel
that's
a
the
lot
problem.
better
It's confusing
about
everyone, so don't worry, you're
That's
not on your
okay.
own.
So,
But it's Articles 5 to 17 of the draft amending law.
Yep. Okay. Thank you, sir. So the areas which this covers, I think, sir, I must point out an irony when there's talk about hustings fatigue, and the Assembly has voted for another type of hustings which will take place. 12 of them, for whoever's going to stand for senators, will have to attend all 12 senatorial hustings, which may have 30 or 40 people stood there and who will talk for about 30 seconds maximum, if that, on every question that's asked. So I think there's a real irony to talk about hustings fatigue when what we've done in this Assembly is brought back the worst form of hustings that you could possibly have to find anything out about a candidate. So in terms of polling stations, this is on a Sunday, the election. I would suggest that in so many jurisdictions around the world, and I've observed a few of them now, I'm quite interested in the way elections are run, and using schools is a really good idea. And the schools will not be open on those days because it's Sunday. It may limit a couple of clubs for one day, but we will know more than a year in advance that they can't use that day. And I think that shouldn't be a problem. And I think it would be a very good idea because schools are so central to our communities. They have car parks quite frequently, they have places to get to, and they are accessible. Also, so it might encourage young people to vote because they don't feel there's a place they would go to. This sounds like a little subtle thing, but young people go to schools, they go to secondary schools, they go to colleges. They may not visit the parish hall very often. If they do, it might be for the wrong reasons sometimes. They might not want to visit the parish hall. And so opening up the schools is a very important thing. I would also suggest, sir, that we need to look at pre-polls. And I think it would be a very, very good idea to have a pre-poll up at somewhere such as Highlands College, which is central to all of the post-16 provision on this island, within a 5 or 10 minute walking distance, to encourage young people to actually vote and be part of our electoral system. And so, as Education Minister, if there's anything I can do to facilitate that, then we certainly will. So I think these are the type of things that we need to do to encourage people to get to the polling station and vote on election day. So I welcome these changes. I think they're very good. Dispute resolution is a problem throughout the world, I think, in elections as to what will be reported, what won't be reported and what will be dealt with. I think the Jersey Election Authority has a real role to play there, and the clarity around what they will or will not deal with is very, very important. And I think if that can be made very, very clear, it will help. I don't think it will stop complaints being made on nothing to do with the JEA, because they just tend to be made on election day because people get angry about things. That just seems to be what happens. And finally, sir, in terms of postal voting, I think we need to be absolutely clarity as to when those postal votes are accountable. If things are I would like to see from the day that they are posted. We often have delays on the island for all sorts of reasons, particularly if postal votes are coming from the UK, for students who are in the UK, and around June time there will still likely be some students in the UK. People might be away for all sorts of reasons, and I think if they take make the effort to take a postal ballot, actually post it on the days beforehand, but it just doesn't arrive because of whatever delay in the postal system, and it's not counted. I don't think that's good for us as a democracy. I recognise it has to be here before election day, but if we're going to set that postal ballot day a significant number of days before election day, we will have a situation whereby postal ballot might arrive 2 days into the 4-day break. I can't remember how many days it was that it was suggested need to be 2 days. If it arrives a day before, we're going to have a grey area, and that will constitute problems, I think, in the long term. It's a small matter, but I think it's an important one to have. And obviously, I wouldn't say anything bad about Jersey Post, but perhaps sometimes they don't arrive as quick as we thought they might either. So there are issues around that. So I'd like to see those things addressed. But other than that, sir, I do feel that these are good steps forward, and I'm happy to support these articles. Thank you, sir.
Thank you, Deputy. Deputy Alex Curtis.
Thank you, sir. And I don't mean to say much on this, but I'm glad we at least have a chance to discuss Article 5, which introduces a new or extended remit for the Jersey Electoral Authority for complaints. The chair of the Corporate Services Scrutiny Panel did mention this in her speech, that it is important that any complaints process is there that to be appropriate and to deal with the correct complaints and isn't there to serve vexatious or frivolous complaints. And I really rise to hope that the proposer in her summing up can provide more detail as to which issues in particular she feels are being caused by not allowing the public to complain and not just candidates, and how this is intended to work. I know that we expect guidance to obviously be issued, but is the idea that a greater number of complaints would be considered legitimate, or is it actually that there are several illegitimate complaints that we aren't able to rule as inadmissible incredibly early? I'm somewhat concerned and worried that elections are always quite can be quite touchy areas, and you can just imagine, or one can just imagine, sir, that people would be quite happy to throw in a couple of complaints on what would be entirely frivolous matters and actually direct away from what should be debated, which are policies and the candidates at play, to trying to use the complaints or process of the electoral authority for that. So further information would really be appreciated on what the impact of widening this is. Lastly, I would like to understand the clarity between the dealing of complaints between election materials on the highways. In the last sitting, we just approved a change to the highways law to provide the power to exempt election advertising material. Of course, that is only subject to the material and its placement complying with the conditions, if any, specified in an order under that law. So I know last election there was a lot of media about where materials were placed. I thought we'd dealt with that one. So before we do go ahead and change and really widen up the scope of a complaints system that we have very little information about how it will function and what it really serves, I would like some more information. Thank you.
Thank you, Deputy. Solicitor General, ready to respond to the question?
Yes, Deputy Scott asked about the JEA and judicial review. I'm not aware that there has as yet been any application for leave to judicially review a decision of the Jersey Electoral Authority, specifically its decision around the resolution of disputes. So I go from first principle, and I advise in this way. First of all, it is a statutory creature established by Article 13A of the Elections Law. Second, under those statutory provisions, it is able to exercise statutory powers, including the resolution of disputes. Those powers are in the nature, in my view, of public law decision-making powers. And they are, in their resolution of disputes capacity, tasked under 13D2 of the law as presently enacted to take such steps as it considers appropriate for the purpose of seeking to address or resolve the complaint. It seems to me in the ordinary course, if an attempt were made to seek leave to judicially review, a court would be likely to approach the JEA's decision-making on the basis that those decisions were amenable to judicial review. The court would assess the decision-making applying the standard judicial review principles. Was the decision lawful? That is to say, was it a decision which the JEA had power to make? Was it a rationally made decision, or was it irrational? And was it procedurally fair? And just bearing in mind the 13D paragraph 2, the JEA may take such steps as it considers appropriate for the purposes of seeking to address or resolve the complaint, one would think that those procedures would have to have due regard to principles of natural justice to afford a fair hearing.
So
Yes, Secretary Scott.
part of my question was about the contents of the Code of Conduct and and in terms of that content, what terms of reference would it refer to? Is it solely kind of, can it only be designed in terms of the support of fair elections, or is it totally up to its discretion?
That's already provided for in Article 13C of the Elections Law, which remains unaltered by these amendments. That provides that the Code of Conduct prepared by the JEA may in particular include guidance on the manner in which candidates are expected to conduct their election campaigns, the use and content of advertisements or other campaign material, whether published in any form, broadcast or circulated online, conduct whilst present at a polling station or at the count. The JEA must publish the Code of Conduct in such manner as it considers appropriate. That provision doesn't appear to me to be exhaustive, because of the reference to, in particular, include guidance on, which would tend to suggest that the Code of Conduct might include other guidance.
Thank you. Another question for the Solicitor General?
I wanted to speak.
Oh, well, we'll come to you in due course, Deputy Scott. I'll make a note of that. Deputy Balash.
So I'm glad to follow Deputy Curtis, because I too would like to express some reservations about Article 5, 2 reservations in fact. The first one is technical, because Article 13D 3 of the law currently gives the states power to make regulations to make further provision about A, the functions and powers of the JEA in respect of complaints made by candidates, and B, the procedure to be followed by the JEA on receipt of a complaint. And it's surprising that although there is an amendment to paragraph 1 to change the nature of the article so as to empower the public, not just a candidate, to make a complaint. That has not been reflected in paragraph 3. So there's an inconsistency, or there would be an inconsistency if this was adopted, because paragraph 1 would refer to the public, and paragraph 3 would refer to complaints made by candidates. So the states would have power, in other words, to make regulations in respect of complaints by candidates, but not have the power to make regulations in respect of complaints made by the public. And that seems to me to be not right. The second reservation, though, is very much on the lines of Deputy Curtis's observations, and I wonder if we are not opening a Pandora's box by allowing complaints by the general public. It's not clear to me how many complaints are envisaged. Is this going to turn the JEA into a kind of ombudsman or complaints authority? If any member of the public can complain, many of them may. And more importantly, what will the JEA do about these complaints? It's not clear to me what they will, because although there may be some information in the JEA's report as to how they dealt with any complaints that were made by candidates in the last election, I don't know what they are. I mean, in summary, so I think I'm just not clear about what is envisaged for this potentially very large power to be conferred on the JEA. and I would have liked to have seen much more clarity about what we envisage to be the consequence of conferring this power.
Thank you, Deputy Gardner.
Thank you, and I'm grateful for the Deputy Curtis to raising this point. I have one question, and I would like to hear from the Chair of PPC. When and how nominations, if new nominations of the new members for the Jersey Election Authority will take place, and would we have different requirements for nominated members to consider, which will be based on decisions that will be made today? Because if we are changing the roles of the Jersey Election Authority, we need to consider who will be dealing, what type of candidates will be on, needs to be there. And I'm hearing Deputy Balash, who raised really, really valid points. What will be the foundation, the base to handling, and once we're opening, it's really, really wide. And I'm worried if it will not become political pinko battlefield. But I would listen to the response.
Deputy Joseph.
Thank you, sir. I am grateful for Deputy Curtis to raise the issue of Article 5 because we're giving voters a new right to complain. So I'm not sure how we're going to end up in the elections, but I hope that everybody doesn't complain, or else we'll need a complaint panel for a complaints panel. This amendment, as the previous speakers have said, opens a door. And I think that we're walking into another a room without the finished furnishing that's clear. Until the JEA actually publishes detailed rules, we won't yet know, except what they're trying to say, and I understand what PPC is saying, that they want to follow the UK Electoral Authority. But who's going to say whether this guidance or whatever they're going to say is valid or not? We've heard a lot about the Commission of Standards and certain issues about that. There is a concern about making things up as you go along. And I think that democracy is not well served by that. And I wonder very kindly if the President of PPC would explain, if she could, what guidance is going to be issued, when, and who's going to authorise it, if I may ask. Because otherwise, we risk turning, I think, as the Deputy Balash and I think Deputy Curtis was trying to say, we end up running into a fairness into fog. I welcome potentially the opportunity for people to complain. That's all fine, but I propose an ombudsman. I don't know where that's gone. Don't think it's going anywhere. It has to come with a filter, not a funnel. And we're opening the door for something that's a general right for the public, which I just don't understand. And if it's not prescribed, I don't want to criticise PPC because I know they've got a really difficult job. And the Electoral Commission, I'm really concerned whether or not we're actually giving them an absolutely unworkable thing to do. And so I legitimately am waiting to be persuaded. But at the moment, I'm not sure. And I don't know whether or not we can vote against it because I'm not sure whether we're going to have to come back to some of these issues. Dare I raise the issue of the senatorial legislation, which is not before us, but I welcome, and I know the chair of PPC is bringing this forward as quickly as she can. What is absolutely clear, sir, is that in the past, hustings have been a muddle, and there has been a concern about the organisation of it. It's fine for St Saviour, I suppose, one parish, not three. We're much easier, we're simple. And we can have one in the north or the south. But multi-seat constituencies, which are a great thing, because it's legitimising democracy, have got to have some organisation. And dare I say it, sir, but if we've agreed the principle of senators, but I'm not sure we've actually agreed whether or not we're going to have it on the same day. And I know that the likely senatorial candidates really want to come back into this assembly and with a sort of real swagger about them, and because they're important, they've been elected island-wide. But at the end of the day, sir, we're all equal in here. And I think that, yes, they will have done a marathon of hustings, 12, but maybe that's going to be fixed because they won't have done a marathon of 12 because we're going to have some some sense, and I know the late great Senator Shenton was the one I was corrected on having brought in the parish-wide. Every parish has to have a hustings. But sir, I'm worried about the standing of the deputies and the constables, and I'm worried that we're going to make sure. I welcome this proposal, but I do worry about what we're getting to. And I think it's right that we're going to have an arrangement whereby we can have hustings, because it's got to be fair. Everybody in this assembly is free, is equal. Whether or not they get elected by the curious senatorial hustings process or not, which is not really about that. And I would say without this very welcome article, we're going to be in place of basically, we're going to have a hustings law where we're going to need a spreadsheet and a time machine and a clone to get to all of them. It's going to be really difficult for voters to decide, do they go to the deputies' hustings? Do they go to the senators' one? Do they go to the constables? And which one do they go to? It's just mind-boggling. And are the candidates got to go to the three hustings in the 3 different parishes that they represent? I mean, we're confused. People, I know everybody wants to have more votes and all the rest of it, but we're creating a potential nightmare. We're creating a nightmare because it's going to be very difficult. But that's not an issue for today. I want us to have democracy, sir, not a farce. So I welcome this arrangement, but I worry about where it's going to have and how it's going to work in the longer term. I have a little concern, if I may, sir, about the issue of postal voting. The postal voting is now going to be brought forward. We're going to have a really strong campaign to say, get your vote in early, otherwise you won't have your postal vote. And I'm not exactly sure whether it's quite right, if I may very respectfully say, to say that the postal vote is invalid if it doesn't come up, if it doesn't get there before the day before. I just don't understand that, actually. I really want to be constructive, but I'm not sure about that. It's really important that we have democracy. It's really important that democracy seems to work fairly and actually does work fairly. We've got great things in our democracy. We've made some huge improvements, and I just wouldn't want us to be in a position of doing things inadvertently. And I know the PPC's got a very difficult job on their hands in trying to basically meld this issue forward. And I welcome all of these articles with one question about the postal vote issue, well, 2 questions, the postal vote deadline. I'm not sure it's right that it's right to say that if a postal vote lands 2 days late, it's a vote not counted. Is there any discretion at all? I'm not sure I'm comfortable with that, especially when the vote is actually on the day. And actually for the complaints panel, I'm not sure whether the chair is not actually opening a Pandora's box, as Deputy Balash and others have said. It's really difficult, this. Without guidance, we really don't know what we're going to be doing. So I'm worried about that, and I want to be really nice to the chair of PPC because she is a zeitgeist, she's brilliant, but she's got a very difficult job to do.
Thank you, Deputy. Deputy Scott.
So, like others in this assembly, I totally appreciate the positive intention of the articles that we're discussing. But I also am perturbed because I see an inconsistency in terms of how the PPC have put forward these changes where they're giving power to the Jersey Electoral Authority, to members of the electorate, in the context of elections which can get extremely nasty, the discrediting of others, saying, okay, here you are, the JEA would like you to take some sort of control here and some sort of almost like regulatory, and dare I say even an investigative role. And at the same time, there hasn't been an amendment that perhaps can ensure that when this is done in a way which is perhaps can be better thought out. So I refer to the Pandora's box that Deputy Balash has referred to, and the hand tying, because there's no amendment of Article 13d3 of the main law that allows regulations that can mean the States Assembly can actually how can I say, offer a bit more in the way of tram lines in terms of what is produced in this way. I think it, and I'm going to contrast this with the comments that were reduced in terms of the proposition that I put forward, where power is, it's been suggested certain members of the community of power, but very much subject to what I would say safeguards, and that there's been a reluctance to do that. And this comes back to the whole point, the whole process of scrutiny itself. The devil is in the detail. And in an ideal world, I would have, I'm thinking, okay, some GREF officers have advised PPC in terms of this detail. Some GREF officers have, I presume, advised the corporate scrutiny and corporate services scrutiny panel in respect of the scrutiny of the law. But even now, where are we? We've got members of the Assembly of certain background who are just saying, well, hold on, really, maybe this might have been thought through a bit more before we, the states members, who generally, and I'm not criticising anybody for this, I know often people must think, God, you know, that deputy's now getting into the detail and we hate it. Many people are quite high level. And that's okay, but you need that balance. You really need that balance to make good law, to make good results for the community, and dare I say, even for us. So, sir, I'm going to propose a reference back under Standing Order 83, because I do believe there's a Pandora's box here. I do believe that it merits some further consideration by the PPC before we go on to approve these particular provision without the PPC perhaps considering a bit more, perhaps the an accompanying amendment of 13D3, or even just the whole basis that there's going to be a code of conduct. That's what people will be measured against it. If there are complaints, that will be investigated. What's the process there? What's the resourcing for that? There's many questions, and the fact is that I've been aware of more and more independent bodies popping up with inconsistent rules about how they operate, even how they publicise information. And it's got to be thought through before, you know, as we try and gather up all this stuff and maybe have an ombudsman, or maybe not. Maybe we can change the States of Jersey complaints panel that only can look at ministerial portfolios. I mean, it is a bit of a mess, I'm sorry. So, anyway.
Deputy Scott, if you are proposing a reference back, and I note the time, it's 23 minutes past 5, it's necessary for you to specify with some care what the purpose of the reference back is.
The purpose of the reference back, sir.
It may be, if the adjournment was proposed now, that's something you could reflect on overnight, so you can tell members with some precision tomorrow morning precisely why it is you think this should be referred back, so they can consider that tomorrow morning when we'll debate your proposal for reference back.
So, sir, I'll propose an adjournment first.
Sir, may I speak? I think if somebody is going to propose a reference back, they should have thought what the reference back was at the beginning when they stood up and said, I'm going to propose a reference back, and therefore be able to immediately say, I want a reference back for this point. Yeah. That's what the standing order reads to me. And saying, I'll propose a reference back, but I'll have a think about it overnight and come back in the morning and see what it is, doesn't strike me as fair to us, sir.
Well, I follow that, but a member is entitled to propose without notice a reference back. And I'm asking the member, we only have 6 minutes left today, to consider overnight the basis upon which she wishes to propose a reference back. And then I think we'll all be in a better place, including the proposer and members of the Assembly considering it. But it's a matter of the Assembly, it's only my suggestion.
So can I just ask, has Deputy Scott finished her speech, or is she in the middle of it?
I don't know. Let's
ask. So I think
let's find out.
So the natural...
Debbie Scott, you're still speaking, are you presumably?
So I finished my speech with a proposal that we have a reference back, but I've actually...
Let you speak. Yes.
that hasn't been seconded, so in the meantime I'm going to propose an adjournment, but I will be proposing a reference back. I personally would be quite happy to explain to members right now why there should be a reference back, but I guess you should just basically decide whether you want to have a rest and support an adjournment first. You don't have to, and if you don't, I'll propose a reference back.
Well, I thought you proposed the adjournment. Have you proposed the adjournment? Are members content to adjourn now?
No, sir. No. Can I speak on why?
On why you don't want to adjourn? Yes, you can. The proposal is to adjourn now. The proposal for reference back, the deputy's mentioned, and she'll pursue that tomorrow morning, but the proposal she's just made is to adjourn.
So I think this is highly unsatisfactory. We've got 5 minutes of ordinary time left to debate, and ordinarily what would happen is that Deputy Scott should finish her speech. She could take a full 15 minutes if she wanted to, and then at the end of it she could decide whether she wants to move a reference back.
The adjournment has been proposed.
I know,
And
sir, and I'm
stick to
just
procedure.
explaining why I don't think this process has been satisfactory, why we shouldn't adjourn now.
My
As far as I'm
adjournment's
concerned,
please.
Deputy Scott's made her speech, she's finished her speech. I'm next in line to speak. I'm happy to speak no longer than 5 minutes to take us to 5:30.
She's proposed the adjournment.
I know, sir, and that's why I'm saying I don't want to adjourn, because I'd like to make a short speech. One time offer only, it may not be the case in the morning. I may have to speak in the morning, of course, on a reference back and make another 15-minute speech after that. So I propose that we don't adjourn now. I make a short 5-minute speech, maybe less, and that if somebody in the meantime wants to make a reference back or not, then we should decide that, I think, this evening before we adjourn. I don't think it's satisfactory to adjourn and to curtail this just so that we can then consider that otherwise.
I'm going to put this to the vote now. The question is...
Are we allowed to speak on this?
No. These procedural matters are really for the presiding officer to deal with, and if we have a long debate on whether to adjourn, then it will make the whole thing unmanageable. So I'm going to put it to the members now. If you wish to adjourn, you'll vote pour. If you wish to carry on, you'll vote conch. I ask the greffier to open the voting. Proposal is to adjourn. If all members have the opportunity of casting their votes, I ask the greffier to close the voting. And the Assembly has agreed to adjourn now. 28 votes pour, 14 votes conch, and 2 abstentions. So the states are adjourned until 9:30 tomorrow morning.